And number 1 and 2, top of the list. Why there are two petitions?
My lord, one writ petition is with regard to the boundary wall matter. Another writ petition, my lord, we say that if the land is which is allotted to us, if it is not used for that purpose, then the land should be we should pay the compensation and other things.
5985.
5985 is the issue with regard to what. That is, my lord, the is the extension of the township, my lord, where construction was there, my lord. My lordship have seasoned with that matter, my lord, that where construction of the quarters were there, my lord. So that extension, my lord, we have a boundary wall in 2011 throughout the area, my lord. Now, there was an objection that is, my lord, that Rohit Chaudhary filed a petition, my lord, saying that that is an obstruction of elephant, my lord, and it's the elephant corridor.
If I may be permitted to interrupt this first writ petition 5985 in my humble submission has become inconsistent. Reason being, my lord, the entity had passed a very detailed judgment. I am representing Rohit Chaudhary, the person I don't know has this next about. Rohit Chaudhary had filed an OA before the entity with regard to this elephant corridor as well as no development zone and everything. And the entity in its detailed judgment passed in 2016 had given directions. 2016, 24/8/2016. If your lordship kindly takes up the IA petition, I can refer from there.
No, it is there.
It is annexure 2 to the IA. Probably the file that your lordship is having.
Petition 5985. What is the annexure 2?
Lordship. So this MGT order, it is a detailed order, my lord, and it not only covers the NRL property or the township area which they propose to develop, it also deals with the entire stretch of land from Kaziranga to NRL plus the Devpahar Reserve Forest area. Everything has been dealt with, and detailed directions have been given at paragraph 32, my lord. Before concluding, we may revisit some of major issues that were dealt with. From the rival contentions and the documents on record, it is clear that a high wall has been constructed in 2011 for the proposed new township with barbed wire fencing, which comes in the way of elephant corridor. At the same time, the importance of elephant corridor for migration and regeneration of their species has been fully brought out in the foregoing paragraphs. As to the question whether the said wall is in violation of the no development zone notification of MOEF issued in 1996.
Now kindly come to page paragraph 33.
My lord. Paragraph 33, in conclusion, we issue the following directives. As regards the wall with barbed wire fencing, which comes in the way of elephant corridor, the same should be demolished. That was the first directive. The area where the wall has come up and the proposed township is to come up is a part of Devpahar PRF. It also falls within the no development zone notification issued by the MOEF in 1996. Thereby, any non-forest activity thereon would be in violation of the decision of Apex Court in the TN Godavarman case. Thus, the wall should be demolished within a period of 1 month, and the proposed township should not come up in the present location.
So now, it is the wall which is being the subject matter.
Yes, my lord. Yes, my lord. It is this wall.
The wall, which is, it is, lordship, to see the wall with barbed wire fencing, which comes in the way of elephant corridor. So out of matter, we got 67 bighas of land. There, my lord, 7 bighas land found to be under Devpahar Reserve Forest, within Devpahar Reserve Forest. So we demolished the wall to that extent. Now there is some change, my lord. Lordship, when the matter came up on 14/9/2022 and 27/9/22, the writ petitioner was present, the vacating petition was to be heard, then this honorable court has constituted a committee, my lord. Lordship may just
No,
say,
no, no, sir. Why all this committee will in the business?
Yeah.
There's no business of the committee.
Right.
You want a clarification, you go to NGT.
Yes, my lord. And plus,
What is this court have? Why, there is an order being passed by the NGT. You have want to say that if you have that is in 7 because is this or 67 because that is that. Why should this court consider
Ma'am,
when the NGT is
apart
there?
from that,
You
they have
want a
referred a review, my
clarification
lord.
that it should only be limited to this section. Go
Yes.
to the
My lord,
NGT.
after this
Lordship
judgment,
is-
the review was referred. The review petition was also dismissed by the NGT.
Review was filed against
Yes,
this.
my lord.
Yes,
Against this
Lordship may see
particular judgment, review was filed. That was also dismissed on 3/8/2018.
Show me where is that?
My
Lordship may
lord,
see
in the
page
IA, it is
100,
annexure C.
116, my lord, to the writ.
My lord, review was dismissed. Then the government was trying to demolish the wall. As such, the first writ petition, that is 5985, was filed before the
Wait,
Honorable
wait, wait. What is the order? Here, it of the year.
Lordship,
2018.
118 page, notice, and then
Para
Okay,
7 is.
okay.
para 4 and 5, my lord.
Paragraph. So it's a direct. What did you ask for? The review? Following facts were noted from the above. That aspect to clarify. The state wall up to improve. When did you construct this?
2011, my lord.
This is the wall.
The boundary wall,
The entire boundary wall was constructed in the year 2011.
2011.
Okay, now let's come to paragraph page 116.
Yes, my lord.
Now, what is the content of paragraph 19 there? Let us read. From the above mentioned letter of the TF4, the video clippings where the editor tried the state of the applicant activity well verified that it is clear that the NRL had constructed the boundary wall in 2011
11.
for construction of the proposed expansion of phase 3 of their residential complex, and the said wall is coming in the way of the elephant corridor. Said wall is also encroaching upon the barbed wire, and the razor edge fencing along with the said wall is extremely dangerous to the human. As a result, some elephants have died after the and as the elephant corridor have been the wall and the proposed are in violation.
Help.
The highlight was has been constructed during phase 1. The township which saw the boundary between the highly dense and the water. This wall has been barbed with razor wire which is so evident that it has muted the heat
Covering about.
protected. Accordingly, the flowing current has cut the wall with barbed wire with the area where the wall has the interior submitted the project as the clearance of the state declared notice was issued to the review applicant. State of Assam has taken that the review is required 700 let's secure it with positive of year 1996, whereas the full township. The review period acquired additional 67 bigha tea garden land and secured it with a boundary wall in the year 2011, wherein the review started construction of the residential block. Presently, the reviewer has absolute lawful possession over the land measuring 750 plus out of them newly acquired 67 acres under the possession of the 7 because falls in Deoghar, but the originally proposed Deoghar for the state on the plan of the next new meeting and the it to it the it to submit to the entire and need not be the table. We are of the view that the categorical finding already reported by the area where the all came and the area where the proposed hearing. Then what up?
Then
Now you have to go to Supreme Court.
Supreme Court already
Supreme Court we
dismissed.
went and the Supreme Court.
Madam,
Sorry, Madam.
you take
Sorry,
your
Madam.
seat. Don't be anxious. I know what is how to control the court. Yes,
Then we went to Supreme Court matter and Supreme Court dismissed the essay.
then
Now Lordship may see.
so you want this
No.
court now to
No, para 190, page 119, Lordship may see the last part. Execution application, that is also dismissed. In view of the no further order is necessary on the application, same time disposed of. So their execution application,
no, obviously because there is a direction given and they will comply with. That is not in the material.
no.
If
We
the
have-
execution application is dismissed, that has no relevance out there. The question is, when there is an order passed by the NCT to pass an order, you went to the Supreme Court against that review order. You have challenged it. And your review petition was specifically not to, that it should not be done in respect to all the entire 67 because or a part of it, but only a part of it taking into account that 1 hectare of land falls in the Deoghar as
Yes.
per the stand of the government.
Yes.
Now that has not been, the SLP has been dismissed. How can this court now sit under 226 over this?
Then Lordship may see the government affidavit, my lord.
I'm not going to look into this government affidavit. All these things have been already adjudicated by the, yeah. And when the very stand of the government affidavit
Hello.
was before the NGT and the NGT has did not look into it. And even that, the Supreme Court also did not look into it. I can't help you.
But Lordship may just for a moment, my lord, page 113 may be seen, my lord, government affidavit. Whether in compliance of order 75/2018, there the stand of the government, Lordship may just see for 180.
Can the government affidavit be anything better than what it was done on 19/3/2017, which is recorded in the review order? No. This is what the government must have stated.
The government has stated that, Lordship, just for a moment, para 4 and 5,
Page
page 113.
Yeah.
That the Numaligarh refinery.
Yeah, this is what has been already recorded out there.
Yes, that's what I'm saying.
Nothing can help you.
Well, as of
Nothing,
now,
no case.
and
Okay, this is
Lordship,
one. But two, what is the other one?
Lordship, Lordship, you see that order dated 14/9/22, my.
Huh?
14/9/22, order will be seen, my.
This court,
This court.
which petition?
This is the petition, my lord. First petition, my.
No, it
14
in the IAML.
IML. Because when the vacating petition was heard, my lord, at that time this order was passed. Pursuant to the deliberation in the court on 8/9/22, 3 experts on the character, behavior, and natural movement of elephant, namely Shri Tudu Bijan Chaudhary, elephant expert Shri Kaushik Borba,
I'm not going to look on for these orders. When the matter has already been finally dealt with by the NGT and thereafter the Supreme Court has dismissed it, why should this court reopen something which is closed? There's nothing out there. All these things which have been done, it is all interim orders or whatever orders are there. The orders have already. Yes, wait a second.
Second revision.
What is it?
My prayer is at page 31. my lord.
Not be to declaring the petition I have complied with the directions of the Imam. In the face of the stand of the state law, I if I not omit it, but I the same first two, 1, 2, and 3
My lord.
has no relevance. The prayer. Number 4 has some relevance. Is it a question of acquisition to that effect? It is another aspect. But 1, 2, and 3 has no relevance. As to whether the government could reacquire back the land from you by paying 1 crore 76. That is your case. Yes, government. You want to reacquire the land? That is his case. That is. Have you given the offer to the government to reacquire? Or have you made this in the
we have not
requisition?
done.
Then can the court issue a writ in the nature of mandamus without the demanding of justice?
But this
Approve.
is co-
Approve them. Approve them, they will take call. If they don't do so, then obviously the consequences is you know what to do. You said your basic contention therefore is that look here, the government did not inform you that this falls within the Deopa Reserve Forest and allowed you to raise construction or do whatever you like. And by giving you that, by wherein you have paid 1.76. And now, as the act of the government in acquiring the land from the tea garden and giving it to you is bad. So understand that the government should take back the land and pay me that amount. Isn't
is
that
like-
your
my lord, the fact remains like, as of today, my lord, out of this 9-hectare land, 1 hectare land is found to be within the FR reserve forest. So that we have complied with the order. We have broken the wall.
You see, you are asking a declaration from this court of an order being passed by the NGT, and this court should give a declaration. My goodness. Tomorrow, this court will pass some order and, and, and you may go to the district judge with a declaration of a truth that the High Court order has been complied. Which is the authority before whom you have to go taking that declaration? The NGT. NGT has to be satisfied, yes, you have complied with that order. And we would have the yes, the matter was pending. You did not move the SLP, and this court can look into something under 226. You removed the SLP. The SLP was dismissed. Matter is
Lordship will see that order, my lord.
okay, right? This is
And
not a fit case for being in on a Tuesday list.
Lordship sees the direction, my lord. Lordship sees the direction at page 55, my lord.
Of who?
This 5985 of 2018.
Who's direction?
NGT's direction.
I'm not going to look into it. Because the entity who have categorically the government has taken a step saying that only 1 hectare is there.
Yeah.
And that wall of 1 hectare can be removed and remaining 8 hectares they can enjoy. That has not been taken into consideration by the entity. Now,
Lordship may see
if
the.
you are asking this court to sit under 226
No, I'm
over
not
the
saying that.
order,
I'm not saying that. Lordship may see the operative portion of the direction, my lord. As regards the wall with barbed wire fencing which comes in the way of elephant corridor, the same should be demolished. So the wall which the fencing comes within that, my lord, the way of elephant corridor.
now do you have any wall?
No, that we have removed it.
Any wall?
A wall,
Except
we
that
have
wall which have been constructed in the year 1996. Any other wall?
We have all 2011 that we have considered.
Yeah. So remove that. That is the wall which has been made more specific out there. Because there are 2 aspects which have been mentioned
Right.
in the review order. First, there was a construction of a wall in the year 1996 when you have taken this 750 acres of land, or bighas of land. Remaining 67 bighas of land which was there you have constructed a wall in the year 2011.
11.
Now, this wall has been, you are saying out there that the government has filed an affidavit saying that look at out of these 67 bighas out there, a portion of it is there. Remaining is not. The NGT did not consider on merit.
NGT, but observe that, my lord. In review petition, lordship may see the para 5. NGT observed that we have surrendered 1 hectare of land. That is there in para 5, my lord, page 119.
Yeah.
Page 119, para 5, my lord.
Further, the affidavit has been filed as written follow.
Well,
This is your affidavit.
Yes,
Therefore, the NGT have taken into account that aspect
right.
and say that we are not touching.
Very good. But then the execution also dismissed, my lord.
So-
That they have filed an execution, my lord. That is also got
So
dismissed.
go to the NGT and say there is no execution. Why they are executing? They are doing in compliance with an order. The execution has been dismissed for whatever reason. That's a different aspect. That has nothing to
Because
do.
we have
Are
complied.
you aggrieved by the fact that the execution has been dismissed?
Dismissed because
Okay, I can exercise 226.
that's a
And
different thing, my
remand.
lord. But but this observation has been taken care of. It then the execution is dismissed, man. And as of today, there is no execution application pending, man.
That's it. So what to do? Dismiss. 2018 onwards, we have been putting a bit of order. Orders passed for that. How many elephants must have died?
No,
My lord,
there is no
wall is
no
still there.
incident, my lord.
Wall is still there, and if lordship those elephants, my lord, and had the wall for some other purpose, we could have understand. This wall is for protecting a golf course. And these are
Not
traditional rules,
golf
my
course,
lord.
my lord.
They from
This is-
Kaziranga, they go to Nagaland, there's national reserve, my lord, in Taki. This is a traditional hard way, man.
Lordship just say the last affidavit we filed it, my lord.
I am not. going
No,
to-
just for a
No,
moment, my
no,
lord.
no. Sorry. You know,
Last affidavit,
Mr. Remaining is for the division bench.
lordship may see
Need
page.
something for the division bench.
No, correct, my lord. But lordship may just for a moment, my lord. Lordship may see page 237, my lord. 237, point number 5.3.
What is it? What have it?
Lordship, this is a report of the committee, my lord.
No.
No,
Committee
just for a
business.
moment, my lord.
This committee business have nothing. This court should not have done anything to that. Wait, what is this committee business of? I'll give you the liberty, go and approach the authorities for the returning the land. That is a different thing. It's nothing to that. All these things, but the committee and all these things, where is the first question of jurisdiction? You have to first see why this court should entertain. Against that, you have moved this court, the Supreme Court has said, Both the requisitions are taken up to the heard Mr. J. Roy, the learned counsel, appearing on behalf of the in both the requisitions. The Ipoh, the learned forest part of the government of that. And would not be appearing on behalf of the revenue. What is that? You are paying for the district administration. Appearing on behalf of the district administration. Which you are appearing. The third. So it was 30 part. And
MSP Agarwal for respondent number.
yeah, that was for the private.
Private.
So, madam, your role was only that extent.
My role was
To
only to
only
take
to
of the
say
boundary
your
wall.
name. Why were you disturbing a part of
I
the
apologize, my lord. I'll be more careful.
Take your seat. Both the requisitions are taken up for disposal by its common order. Taking into account the similarity of the facts that the the record reveals that the private hearing had filed an application before the National Green Tribunal. Before the principal bench, the National Green Tribunal in Delhi, which was registered and numbered as original application number 38 of 2011. In the same application, a missing application was also filed, being registered as misapplication number 787 of 2015. Two misapplications were filed, being registered as miscellaneous application number 787 of 2015 and 1006 of 2000. The National Green Tribunal, for short, NP, passed the judgment on 24/8/2016 in the same miscellaneous application. The conclusions of the same judgment is mentioned in paragraph number 33, which, being relevant, is reproduced here in it. It is relevant to take note that the instant requisition revolves around the directions made at serial number 1 of paragraph 33, wherein it has been mentioned, wherein there was a directive that the wall with barbed wire fencing, which comes in the way of elephant corridor, the same should be demolished. It was also directed that the area where the wall has come up and the proposed township is to come up is a part of the Deobar PRF, which falls within the no development zone notification issued by the Ministry of Environment and Forest in the year 1996. for which any non-forest activity thereon would be in violation of the effects of in T and Godavaran versus Union of India. That T and Godavaran case, bracket 1996. It was categorically directed that a wall should be demolished within a period of 1 month and the proposed township not come up in the present in the state location. Therefore, the petitioner being agreed prepared a review application to the said order dated 24/8/2016. In the said review application, which was registered and numbered at review petition number 29 of the 2016 before the learned NGT. The grounds of review primarily, entirely, whether the learned NGT did not notice the comments of the State Environment Impact Assessment, what is it, SREIAA?
That's a body, man.
What
State
is the name? State
Environment Impact Assessment Authority.
State Environment Impact
Assessment
Assessment
Authority.
Authority.
Yeah.
In its report dated 8/10/2015, that the construction of the boundary wall and the golf course does not require environmental clearance. It was also mentioned, it was also another ground which was taken is that the land measuring 67 bighas was allotted to the petitioner during the period 2004-08 for extension of the existing township by stating that the same is a revenue land and does not form a part of the forest or Deoghar proposed reserve forest in any manner. It was the boundary, the tribunal, the learned NGT in its order 24/8/2016 failed to take note of that the boundary wall with respect to the extension area of the township was constructed in the year 2011. And the private respondent herein filed the petition before the learned entity in August 2015 after 4 years from the lapse of the cause of action. But it's that in the ground of the M and N of the review application, it was mentioned that out of the 67 bighas, only 7 bighas form part of the proposed Deopar Reserve Forest. And therefore, the restriction, if any, should be confined to the 7 bighas only. In the same review proceedings before the learned entity, an affidavit was filed by the respondent state of Assam. Very good. Paragraph number 4, 5, and 6 of the same affidavit being relevant is reproduced hereinunder. It is very pertinent to mention that in paragraph number 5 quoted herein above, it was specifically mentioned, it was stated in that in paragraph number 5, as stated herein above, the state of Assam had stated that out of the 9 hectares of land, 1 hectare originally was notified area of Deopar proposed reserve forest Deopar of 1999. And the petitioner, that is the NRL and Numaligarh Refinery Limited, constructed boundary wall over that 9 hectare acquired land in 2010-11. It was mentioned that in compliance with the order of the learned NGT, a joint dated 24/8/2016, a joint survey was carried out by the Revenue Department and the Forest Department of Golaghat and identified that 1 hectare area, which was earlier included in the Deopar Reserve Forest, the proposed reserve forest in the year 1999. It was further mentioned that the NRL authority had surrendered the said portion of land and the boundary wall covering 1 hectare was demarcated and finally demolished on 13/3/2018. Further to that, this 1 hectare of land had been taken over by the Revenue Department from the NRL. It was also mentioned that this would facilitate free animal movement in the area, as well as for declaration of the Deopar as reserve forest. It was also categorically stated that the balance 8 hectares of land under the possession of the NRL is free from the proposed Deopar reserve forest area. The learned NGT duly have taken note of the affidavit filed by the government of Assam, and thereupon passed an order dated 3/8/2018 thereby dismissing the said review application. On the ground that in view of the categorical finding in the order dated 24/8/2016, that area where the wall had come up and the area where the proposed township is to come up is a part of the Deopar Reserve Forest. Rehearing on merits was not permissible. Where that order SLP?
It's in my lord petition of, it's in petition, but that's,
That I lordship, even
I,
our
also,
additional affidavit also we have in it.
The record further reveals that against both the orders, that is the order dated 24/8/2016, passed in miscellaneous application number 787 of 2015, and in miscellaneous application number 1006 of 2000, and also against the review order dated 3/8/2018 in review number 29 of 2016. An appeal was prepared. Where is the sign of? An appeal was prepared before the Supreme Court, which was registered and numbered as civil appeal diary number 4103 of 2018. Where is the signed order?
I did.
No, here it says the civil appeals are dismissed in terms of the signed order.
my lord, in the
Page
petition.
44. Page 40. That got.
From the above, the said appeal was dismissed by the order date 18/1/2016. Eighteen 2009. In the meantime, pursuant to the order dated 3/8/2018, the district administration had taken steps for demolition of the wall as per the orders passed by the learned entity. It is under such circumstances that WPC number 5985/2018 was filed. Seeking a writ in the nature of mandamus was filed by the petitioner. Seeking a writ in the nature of mandamus. Restraining the Deputy Commissioner Golaghat not to demolish public damage the whole boundary wall, and also to interfere with the impugned proposed actions of the demolition of the entire boundary wall of the township extension by the Deputy Commissioner. The record reveals that pursuant to the filing of the said order, filing of the instant the said writ petition on 28/8/2018, an order was passed by this court on 3/9/2018, whereby notice was issued and in the interim directed maintenance of status quo as regards the remaining 8 hectares of land till the returnable date. Pursuant thereto, while the said writ petition being WPC number 5985/2018 was pending, an appeal was filed by the petitioner before the Supreme Court against the picnic that it fixed by the pursuant to the dismissal of the appeal filed by the petitioner by the Supreme Court by the order dated 18/1/2019, a writ petition was filed by the petitioner before this court on 6/8/2019. The said writ petition. This is the second writ petition. But I could 6/8. The relief sought for in the state petition is very relevant. Take note of. It was in terms with clause relief number 1. The petitioner sought for a declaration to the effect that the petitioner had complied with the order dated 24/8/2016 passed by the learned NGT. The second relief which have been sought for, that in absence of any notification notifying the area under the elephant corridor by the state of Assam, except the 9 elephant corridors in the state of Assam, an inquiry by an independent wildlife agency should be made to establish whether the entire area of 9 hectares, that is 67 bighas, 0 kata, 13 lectures of land acquired by the state government falls within the elephant corridor. And in the event the same is found to be within the elephant corridor, to affix responsibility on the state government official responsible for allotting the land measuring 9 hectares to the petitioner, undertake the petitioner by wrong usage of public funds for the allotment of the same. The third relief sought for is that the government respondent shall specify that direction be issued to the government respondent to specify as to what permissions are further required under the no development zone for construction by the petitioner undertaking. And in the alternative, it was also prayed that the entire land measuring 9 hectares if held as a part of the elephant corridor, the respondent be directed to take steps to acquire the same from the petitioner in accordance with law by paying rupees 1.76 crore taken for acquisition of 9 hectares of land, that is 67 bighas, 0 kata, 13 lectures of land, together with expenses incurred towards the NRL construction project of NRL extension of township, in addition to solation, interest and charges. The record reveals that pursuant to the filing of the instant report, the second petition by the petitioner, notice was issued by an order dated 26/8/2019. This court also finds it relevant. Take note of that in WBC number 5985/2018, an affidavit in opposition was filed by the respondent number 5. Wherein The fact of acquisition of 67 bighas of land was duly admitted. It was also mentioned that a letter dated 23/8/2018 was issued by the subdivisional officer, civil Bokakhat, to take immediate compliance with the order of the learned NGT dated 3/8/2018 and 24/8/2016. In WBC number 6093 of 2019, affidavit in opposition has been filed by the respondent number 6, that is the divisional forest officer, Golaghat Division, as well as the respondent number 9, who is the private respondent. From a perusal of the affidavit in opposition filed by the respondent number 6, it was categorically mentioned at paragraph number 6 that the acquired 67 bighas, 0.30 acres of land which was handed over to the petitioner forms a part of the traditional elephant corridor of the habitat. It was also mentioned that the state level environment impact assessment authority, while granting the clearance, did not consult with the chief wildlife warden, Assam, to confirm as to whether the project obstructs the movement of wildlife, wild elephant, since Assam is a biological hotspot and significantly rich in wild elephants besides other wildlife. It was also mentioned that the divisional forest officer Golaghat Division had also begun a communication on 27/5/2015 to the members secretary, the state level environment impact assessment authority. For cancellation of the suspension of the environmental clearance granted for township extension area, as the area was very close to the Deopar proposed the forest and fell within the no development zone. Moreover, the construction of a huge boundary wall of more than 2,000 meters in length was seriously disturbing of the obstructing the movement of wild elephants along with other traditional migratory routes, along their traditional migratory routes. Besides, NRLS had also started the construction of a golf course very close to the Deopar proposed reserve forest by removing forest cover, cutting and mining the highland, hillocks, etc. For which the divisional forest officer Golaghat had seized the machinery used at the site for clearing the traditional elephant corridor habitat. To the same affidavit in opposition filed by the respondent number 6, the petitioner filed an affidavit in reply. Primarily contending that in absence of any notification notifying the areas under the elephant corridor by the state of Assam, except the existing 9 elephant corridors in the state of Assam, an inquiry by the independent wildlife agency shall be made to establish whether the entire area of 9 hectares, that is 67 because 0 kata 13 acres of land acquired by the state government falls within the elephant corridor. And in the event the state found to be within the elephant corridor, to effect responsibility of the state government officials responsible for allotting the land measuring 9 hectares to the petitioner undertake by wrong usage of the public funds for allotment of the same. It was also mentioned that the statements made in paragraph number 6 of the affidavit by the respondent number 6 was not backed by any documents. Apart from that, the wall was constructed in the year 2011 and the divisional forest officer Golaghat division did not issue any communication prior to the construction of the wall or even at the time of construction of the wall, but issued the communication only on 27/5/2015. It was also mentioned that the Supreme Court, by order dated 18/1/2019, did not entertain the SL filed by the petitioner. However, on the very next day, that is on 19/1/2019, the government of Assam Environment, Forest, Dispute, in exercise of the powers under the Assam Forest Regulation 1891, declared the area described in the dispute to be a reserve forest, namely Deopar Reserve Forest, with effect on the date of the notification. It was also mentioned that the SEIAA is the authority to grant environment clearance and the demarcation of 1 hectare of land was done in presence of the revenue authority, and consequently the boundary was over the 1 hectare of land was demolished and the revenue authority took over the state. It was also mentioned that the petitioner therefore have duly complied with the directions passed by the learned NGT. In the backdrop of the above reading, this court have also heard the learned counsel appearing on behalf of the party. Mr. J. Roy, the learned senior counsel, appearing on behalf of the petitioner, submitted that out of the 9 hectares of land, 1 hectare fell within the Deopa Reserve Forest. And the remaining 8 hectares of land was outside the Deopa Reserve Forest. And as such, the boundary wall which is standing in the to guard the remaining 8 hectares of land is required to be protected. He further submitted that the instant that although the review application was dismissed, but the execution application so filed by the private respondent was also dismissed, meaning thereby that the learned entity was of the opinion that after the demolition of the wall of the wall pertaining to the 1 hectare of land which fell in the Deopa Reserve Forest, nothing further is required to be done. That's your submission. That is why the execution was dismissed here. He further submitted that in the earlier that various orders have been passed in WTC in the instant proceedings for constituting a committee. And a report has been also submitted. And this very report is in favor of the petitioner.
Not favor, my lord, but the committee said that northern boundary wall so far as concerned, that can be demolished, my lord. Rest is not required, my lord. There is a
Very, the said committee had given certain observations. If these observations are duly taken note of, the entire boundary wall need not be demolished. Anything else? Mr. Tito Boy, the learned counsel, appearing on behalf of the Forest Department, submitted that the entire land of 67 bighas and odd falls in the elephant corridor.
Additional elephant corridor.
In fact, to 2022 till date, my lord, there is no objection because Forest Department also party to that committee. But they also went.
Mr. I have said what you all did not say. I have put it
No, I'm
out
saying
there.
that, my lord.
Now, what he will submit is as per what has been given in paragraph number 6 of the
6 and 5 also.
6
and 5. 2021 meter wall still standing and obstructing
means
some of
that
it.
the entire land measuring 67 bighas, 0 katha 13 letters, 13 letters, which was acquired and handed over to the NRS, to the petition, forms a part of the traditional elephant corridor of the habitat. He therefore submitted that the learned NGT had duly taken note of the same in its orders dated 24/6/2000, but the orders dated
24/8, 2016.
24/8/2016, as well as also in the review order dated 3/8/2018. And therefore passed appropriate directions. He further submitted that in view of the construction of the said wall, which runs of more than 2,000 meters in length, is seriously disturbing or obstructing the movement of wild elephants along their traditional migratory route. He further submitted that the clearance certificate which the petitioner have obtained from the SEIAA was issued without making any consultation with the chief wildlife warden, Assam, which ought to have been done taking into account that Assam is a biological hotspot and significantly rich in wild elephants besides other wildlife. Indicate
That SIA was moved to cancel that clearance. That's what.
he further submitted that the clearance was received only on 24/7/2013, and thereupon immediately on coming to learn in the year 2015, the SIA was moved, the member secretary of SIA, SEIAA, was requested to cancel the clearance. What did you submit?
That's the letter document. That-
Is the way is that what instruction after that? Judgment too much Mr. N. Goswami, the learned counsel appearing on behalf of the district administration, submitted that the district administration have taken steps in accordance with the orders passed by the learned entity. He further submitted that the petitioners have never approached the state responsive authorities for return of the land. And as such, the relief which have been sought for cannot be agitated in the instant proceeding. He submit that it is a well-settled principle of law that if a read in the nature of whatever has been sought for, the petitioner has first demand for justice. Apart from the above, the learned counsel further submits that as to what amount the state government may have to pay are questions pertaining to damages which can only be decided in a civil proceeding and not by. Yes, madam. Now I put your submission. I'm coming in fact. Yes, sir. Okay.
But my submission is very small. Firstly, the entity order should be complied with because it has covered all the aspects related to the entire edifice corridor as well as for development group. The findings are categorical in nature in the order date 24/8/2006. So my second submission is the WPC number 5985 of 2018 has become infructuous because as per para number 24 of the writ petition, it was stated that the government is demolishing the wall, whereas we still have the limitation period of 90 days to prefer an assist. So the reason behind filing the first writ petition was merely because they wanted to go to the Supreme Court to file an SLP. So once the SLP has been dismissed, the cause of action in WPC number 5985 does not survive it. That's all.
Yeah, about that.
Execution application, my lord. I do not have a copy of the execution application.
Is there?
My lord, it is there in the writ petition. It has been enclosed, but the copy of writ petition which is with us, that does not have any of the enclosures.
What do you say? But
My lord,
the
as
order-
far as my knowledge goes, the execution application in my humble submission will not be maintainable before the honorable NGT because it is not a civil court. The civil court will have to execute the order pass.
There is a-
25, Lord. 25. 25, section 25.
Yeah. Take a- Hmm.
Sorry, my lord, that's up. That's power of. In the writ petition, see the copy of application has been annexed. The order is not annexed.
Uh, Yes. What's your name?
P. Agarwal.
P. Agarwal.
P.
P.
Agarwal.
P. Agarwal. It is part of the private phone subject. That the relief which have been sought for in the instant proceeding are in respect to issues which have been which already have attained final in view of the orders passed by the learned NGT dated 24/8/2016 and 3/8/2018, and the same having been also, and those orders having also not being interfered with by the Supreme Court in the civil appeal so filed, whereby the said civil appeal was dismissed. She therefore submitted that the petitioner herein is trying to re-agitate the matter which have been already finally concluded. The learned counsel further submitted that a perusal of paragraph number 24 in WPC number 5985/2018 could clearly show that the primary grievance of the petitioner herein was that the petitioner had a period of 90 days for filing an appeal before the Supreme Court against the order dated 24/8/2016 and 3/8/2018. And even prior to the expiry of the said period, the respondents in the district administration have taken action. They therefore submitted that with the dismissal of the civil appeal filed by the petitioner by order dated 18/1/2019, WPC number 5985/2018 has become infructuous. On the question of on the submission pertaining to the execution application being dismissed as held in the order dated 3/8/2018, on the submission made by the learned counsel appearing on behalf of the petitioner, that the execution application was disposed of, was dismissed. The learned counsel submitted that the learned entity may have been, had only held that no further order was required in the execution application in view of the specific directions already passed in the order dated 24/8/2016. In the backdrop of the above narrative of the facts and the submissions made by the respective parties, let this court therefore analyze as to whether the the reputation as to whether any writ can be issued in exercise of the jurisdiction under Article 2 to 6 of the Constitution. The facts narrated supra would clearly show that the learned entity in its order dated 24/8/2016 had categorically held that the wall with barbed wire fencing comes in the way of elephant corridor, and the same is required to be demolished. And there was a specific direction for demolishing of the said wall within a period of 1 month. The said direction, the petitioner being aggrieved by the said direction, sought for review on various grounds already mentioned above. The learned entity had duly taken into consideration the affidavit filed by the state government, more particularly the paragraphs 4, 5, and 6, which have been quoted here in above. These paragraphs categorically mention that out of 9 hectares of land which was settled with the petitioner, 8 hectares were outside the Deopar Reserve Forest, and only 1 hectare was fell within the Deopar Reserve Forest. It was also mentioned that this 1 hectare of land, in respect to this 1 hectare of land, the boundary wall was demolished, and thereupon the said land was handed back to the revenue authorities. In spite of the said categorical categorical stand taken by the state of Assam in the affidavit, the learned entity did not find it to be a ground for review, and accordingly dismissed the said review application by an order dated 3/8/2018. At this stage, this court finds it very pertinent to take note of that Section 22 of the National Green Tribunals Act 2010 stipulates that any person aggrieved by an award, decision, or order of the tribunal may file an appeal to the Supreme Court within 90 days from the date of communication of the award, decision, or order of the tribunal to him, or on any one or more of the grounds specified in Section 100 of the Code of Civil Procedure. Accordingly, the petitioners herein filed an appeal in terms with Section 22 of the National Green Tribunals Act 2010, and the same was registered as civil appeal number 41203 of the 2018. The said civil appeal was dismissed primarily on the ground that the Supreme Court, with primarily with the observation that the Supreme Court did not find any merits in the said appeal. Accordingly, the observations were made by the learned entity in the order dated 24/8/2016, as well as the order dated 3/8/2018 in the review petition have attained finally. In the backdrop of this above, if this court duly takes note of the actions which have been taken by the district administration, which have been complained in WPC number 5985/2018, it would be seen that the same has been done in consequence. Same have been done on the basis of the orders passed by the learned entity. And as such, as the orders passed by the learned entity have attained finally, it's the orders, the action which have been taken by the concerned, by the respondents in the district administration, in the opinion of this court, cannot be faulted. Under such circumstances, the writ which have been sought for in WPC number 5985/2018 cannot be issued in the facts of the instant case. Now coming to the, moving forward, this court find it relevant to take note of that in WPC number 6093/2019, the petitioner has sought for a declaration that the order passed by the learned entity dated 24/8/2016 had been complied with. In the opinion of this court, that the same declaration, the same belief of declaration is totally misconceived, in as much as if the petitioner wants a declaration in respect to the compliance with an order of the learned entity, the petitioner ought to have approached the learned entity and not this court by way of the present petition. The relief number 2 relates to declaration. The relief number 2 and 4 relates to a declaration to making an inquiry as to whether the relief number 2 in WPC number 6093/2019 relates to an inquiry to be conducted as to whether the land which have been settled with the petitioner falls within the animal corridor. It is the opinion of this court that as the matter has been finally adjudicated upon by the learned entity only in the area that it forms a part of the Deoghar Reserve Forest and affects the animal corridor, the same issue can require no further inquiry. As regards the relief number 4, which have been fought for, but further to that, issuing any directions out here, the instant proceed, it direct for conducting an inquiry would be nullifying the effect of final decision which have been arrived at by the learned entity. Under such circumstances, it is the opinion of this court that the question of issuance of any writ in respect to the second relief sought for in WPC number 6093/2019 2019 does not derive. As regards the relief number 3, the petitioner hearing has sought for a direction of the respondent to specify as to what permissions are further required under the no development code for construction by the petitioner. It is not known as to whether the record does not believe as to whether the petitioner has approached the response authority seeking such information. Under such circumstances, this court is not inclined to issue any writ in that regard. Alternatively, the petitioner hearing has said that the respondent state be directed to take steps to again to acquire the right of the petitioner and by paying an amount of rupees 1.76 crore from the petitioner, together with expenses incurred towards NRL construction project of the NRL County, in addition to the donation, interest, charges, and other charges. It is not seen from the records that the petitioner have approached the respondent of concerned respondent authority, and the respondent authority have declined or not considered such request. Treated as may, if it is the case of damages, which is being felt on account of some illegal action on the part of the respondent authority, then in that case, the petitioner would be well advised to approach the appropriate civil court seeking damages in that regard. According both the petitions therefore stands disposed of with the following observations and directions. The order dated 24/8/2018, 24/8/2016, and 3/8/2018 of the learned entity referred to herein above have attained final. Under such circumstances, the action taken by the district administration to comply with the directions of the NCT cannot interfere with by this court under Article 6 of the Constitution. Number 2, the petitioner is not entitled to the reliefs which have been sought for in the instance in Deputy number 609 of 2019 in view of the above analysis and determination. Be that as it may, this court, however, grants the liberty to the petitioner to approach the respondent authority, more particularly the Revenue Department of the Government of Assam, as well as the district administration, as regards the land which was settled to the petitioner and land which was settled to the petitioner, as regards as regards the acquiring of the land which was settled with the petitioner, and if the petitioner is aggrieved by any actions on the part of any actions thereafter, the petitioner would be at liberty to seek appropriate relief in seeking the petitioner would be at liberty to seek appropriate relief in a court.
Liberty may be granted to approach NGT matter.
Huh?
Liberty may be granted to approach NGT matter.
You want to go to NTT, go to NTT. Where
For clarification, part conduct,
It is not going to work. Why should I? But then, say that the issue of the signature, I have now. Because the moment I'm asking, giving them the use the liberty, this court will be now asking again to the entity to reconsider. Why should I keep
Small observation, madam.
what?
The clarification,
The
madam.
law, I have very
Lordship will consider, my lord, we will,
I've given enough. That's about three. Sorry.
so,
I can't give
so
you that.
only,
Who was the entity?
only part of that, my lord, the clarification so far, a 9 hectare land and that 1 hectare we have surrendered. Now, we say that compliance of the NGT direction, my lord. So if anything is there, lordship,
You take what the people of that. I am not going to give their because the moment I give you the liberty, I am giving you a bit allowed then not by the yes, but it is
That matter relating to theme sale, right to transfer of view. Well, that judgment of the Honorable Apex Court,
KP Motika.
yes, that I've gone through.
No, he has to show.
Yes.
Mr. Mohanto, you see that judgment, that case, fishery, I have not gone direct. Yesterday, I told the council, I am not asking them to go for a fresh settlement. No, I'm remanding it back to them for reconsideration after setting aside that you cannot.
Saying that this
That is wrong.
cancellation is bad, so you reconsider. I
Within
am-
15 days.
That is probably,
And you kindly take the certified copy
Yes.
and give it to them.
Yes.
Because that 15 days will start from you taking the
submission of the copy.
to the I have given it to the commissioner, fisheries department. Commissioner and secretary.
I think that is, well,
Because I thought it was making it very complicated. That is that. So
Yes.
yesterday, day before yesterday, I dictated the judgment.
Right.
Then thereafter, I changed it. So yesterday, I informed the other council that this is what I have thought it. Do it within 15 days. Because what will happen with the new model code of conduct
yes,
taking it will be next to impossible.
impossible.
So therefore, I'm like, you give it within 15 days. They will.
I'll be, apply.
Yes,
Lordship, I have a small prayer. Item number 3, 4, and 5 may be taken up
On?
Monday.
it's the-
But my
it-
senior the senior is out of relationship come back.
Who?
See,
yes, what you were saying.
Here I have gone through this one. In fact, I have one more judgment, madam. Perimeter clauses, madam, which has been discussed in KP Modika. There the Honorable Apex Court, that is the chief judge's bench, madam. It has been held that, madam, there was a transfer of right fee. So in the present case, madam, in KP Modika, was a different order was passed.
Yeah.
That is in 2023 SCC 354.
We deal.
It's whether it's Great Eastern Shipping versus State of Karnataka. Same,
It was not taken.
not taken into account, but same perimeter clause. There's also, my lord, that tender conditions were there that, my lord, in case of any, my lord, damage caused, it is the contractor will have to bear the, he will have to indemnify. And Q, my lord, it will have to be provided by the contractor, which has been discussed in KP Modika. It has been held that, my lord, there is no transfer of IP.
If you put that,
Yes, that's why I'm saying. I will rely upon this.
see that,
See that.
but that,
It is Great Eastern Shipping Company Limited versus State of Karnataka.
give it a
2023 SCC 354.
2020.
3 SCC 354.
And this judgment was not taken into account.
No.
They,
We
Monica, they
was
went into
taken
that.
into consideration. There, my lord, PSNL.
They have looked into PSNL and given emphasis on Justice Lakshmanan.
Yes, para 97, 5 conditions. PNB
What
was
is the
taken
name?
in- my lord, it is, my lord, Great Eastern Shipping Company Limited versus State of Karnataka. Shipping Co. Limited versus State of Karnataka.
2020.
Yes, 2023 SCC 354.
These are the-
These are the, my lord, para 25 Florida versus
And KP Modika is 2.
to that. To that. Yes, to that.
I remember. It's Tokai.
Yes.
It's Tokai. It's
And
Tokai.
other been done. There are 25 velocity the clauses has been quoted.
When you have special condition.
Special conditions. Very first one, my lord, all operational costs, including wages, minimum wages act, or any other act allowance, victualling, insurance, hull and repair survey, and other requirements to keep the tug operational will be to the contractor's account, and during any absence of the tug from duty or inability of tug to perform for this or any other reason will result in non-payment of hire charges for the period the tug was not made available to the charterer on pro rata basis, and clause 16 of the charter party agreement shall apply. Now clause 6, charterer will not be responsible for any damage suffered by the tug due to failure of the tug or errors of the tug master and crew or any reason whatsoever. Same way, my lord, clause number 10, the third line, the contractor has to take the insurance policy covering all types of risks of all employees engaged by them.
Clause number
Clause
10 is
te-
contractor has to pay the revised.
No,
premium.
the third line of the same para, same clause.
Shall have take the insurance.
Same way, my lord, 12.
No, these are what is this?
But these are part of the contract, my lord, between
No. What are these?
It was a vessel, my lord, it was to be,
The appellant owns the task.
Yes.
Okay. Now this is the difference. You see, in KP Modika's case,
my lord,
it was a case where various vehicles were,
yes, vehicle, my lord.
and one of the clauses out there happens to be that if that particular vehicle in question
Right.
is not there, you have to give another vehicle.
Yeah.
But here is a case where there is only one task.
Right.
This case.
My lord, yes.
And in this case, what
Same.
is it?
So far
Only
as my
one
lord,
machine.
yes, one machine. So far as my lord,
So there cannot be a substitute of by any other machine.
Right. Right.
So we do not fall into, I don't fall into the trap
yes,
of saying that this
covered by KP Modika. Fine. So they will have to satisfy from the clause that it covers my lord KP Modika.
because they have to show that
Yes.
the term, yeah, because how many here, what was the contract for?
It was regarding my lord. Lawn, sir. Page 42.
Hiring of two numbers
launch
of
vehicles
launch
in
vehicles
connection with
in
the
connection with the
construction
construction
of
of Bukipil field. When
Lot vehicle. Lot, you will find the my lord main condition at page. Yes, page my lord 72.
Hmm.
Page 72.
the launch vehicles shall be operated from here to any other duty. So here, therefore,
Effective control is there, man.
not only effective control.
I know.
This is the vehicle only which can be used.
Yes.
Therefore, this Great India Shipping may have an application,
Yes.
not KP Modi.
Got it.
Because KP Modi, if you see, have you?
Yes, yes.
You see, what are one of the terms is that you could read it.
Got it.
It categorically shows that these, in fact, I remember this KP Modi matter, I was also there. The matter was here with
My
Justice Goel judgment.
Yes.
Which were so in this case where Justice Goel judgment was there, he held that no, that will be applicable.
there was a transfer of right.
They held the transfer of right.
Man,
In fact, if you read these, have you read the Quick Hill?
yes, quick kill, my lord, para 53 has been discussed here. I would rely on 54.
No.
54, my lord.
Yes, the Quick Hill,
Right.
or even if we go back to Rainbow or BSN,
Yes, sir.
they have the right to use it. This person, at this point of time, he have a right over it.
Yes, exactly. Not the,
Yes, that he has the right over that particular, what I think, that's the right.
my lord.
That in that case, it is a transfer or
Right.
by way of a lead.
Right.
Whereas, if it is a case where he is going to provide lead for this particular, and if he is not in a position that if the vehicle is not the main thing, but the carrying of the goods is the main.
Yes.
But the vehicle acts as a conduit for carrying of the weight. Then it is not a transfer of the right to you, but it is a search.
It will be a search.
This is, I think, the most simplest explanation. What do you think, madam? You would obviously not think. Hello. When? Tuesday. No more adjournment. Last time your senior only told the, so I adjourned it. Anyways. No, last time only I asked her, this her senior, as to what is this particular, what do you have to say about this term?
Yes, time to put.
Because here, therefore, the terms out here is these two specific vessels,
Yes, 2 vessels. My lord.
which is there as per in great ship.
Yes.
That is again by treated.
Treated.
And Mojika, the court has considered it to be the work is to be done. And the vehicles are to be used. And as such, one of the most primary conditions is if this vehicle is not there, you have to bring in another vehicle.
Right.
That is one of the factors by which in KP Mojika, the Supreme Court says that is not the question. The vehicle is not the question. It is the work which has the permit. As such,
In fact, KP Mojika also in para 34, the main ground, my lord, why allowed is, my lord, the fact is that para 35, near it is, my lord. Even the trains must be moved and operated by the crew members appointed by the contractor. Moreover, in case of any mishap or accident in connection with the cranes or connection with use of the cranes or as consequence thereof, the entire liability will be of the contractor and not of the vendor. Thus, in short, the contract is for providing the service of cranes to ONGC. The reason is that the transferee, that is ONGC, is not required to face any legal consequences for using the crane supplied by the contract. Therefore, the test laid down in clause 3 and clause D of para 97 of the decision of Dr. A.R. Lakshmanan J are not fulfilled in this. On the legal consequence manner, finally it was held that, my lord, not a transfer of the right.
no,
Whereas-
just for example, I am telling you.
Well.
You today take a vehicle on hire.
Well.
Simple.
Well.
You have taken the vehicle on hire for 30 days.
Yes.
Isn't it the right to use?
Fully, my lord. Yes.
fully?
Yeah.
The driver would be obviously,
It will have to be provided by the, my lord, contract,
not only that,
including the.
can
third
you be
party.
responsible for the vehicle?
Well-
You can't be made responsible for the vehicle.
Sure.
It may be an inclusive,
Yes.
it may
Inclusive
have been
contract.
a hidden thing.
Yes.
That this vehicle contract, I'm paying you this particular price for the purpose that you give me this vehicle, it includes that all expenses, if any, that's borne by you.
Including the insurance and all.
So, yeah, so under such circumstances, it is an inclusive price.
Right.
There can be.
Doctor,
So, can you say it to be a service? No. There's a transfer, but the right to use is yours only.
it's like my lord, my lord, getting in a city bus and going to a particular point. That won't be a my lord
Transfer to
transfer
you.
of it. But if we hire a my lord particular taxi
Hmm.
from the hotel for say from 9 a.m. to 5 p.m. entirely it will be under the control of a particular person. On that day he will be my lord under control. For this particular
That will have a bit different connotations because if you hire it for the 6 hours or 10 hours or whatever it may be, it will be there. But only that will come within the ambit of service.
Right.
Because whether that vehicle is there is not material.
Right.
The vehicle is not the question now.
Doctor,
Because you are not hiring the vehicle number AS010004.
doctor,
You are hiring the vehicle, the services of the vehicle.
doctor.
There's a difference to the effect.
So that vehicle my lord has been my lord para 54.4, which has not been relied upon in my lord KP Modica. It says my lord effective or general control does not mean always physical control.
Hmm.
Or even if the manner, method, methodology, and the time of use of goods is decided by the lessee or the customer, it would be under the effective or general control over it.
No.
Time,
Therefore, I'm saying, if you hire a vehicle which has the number AS01 going for specific,
that's why, yeah.
then it is a right to you. But if you hire a vehicle for 8 hours, it is a service. Because you are not concerned with the vehicle, you are concerned with the service.
Service.
Although the right, you may be using it, but it is a service with you.
Right.
Therefore, you see, in those taxis which you are going,
Right.
you are taking it for 8 hours. They include the service. Because you are not concerned with that vehicle. Therefore, the difference out here, find out with that judgment of which you are doing, and also in the case of this case, as well as this case also, you find out. Here the pinpointed thing is these vessels, or here the pinpointed is the tug.
Yep.
One tug,
One.
2 vessels. These are the 2 specified.
Right.
We want only these 2.
Right.
Whereas in Mojika, it is the work,
Service, yeah.
service, and on the basis of that very service, you are taking out this particular thing. These vehicles form a part of the, or is that act, or is the conduit for giving the, and as such, it is a service, not a transfer of right.
For specific vehicle.
But sometimes you find in Oil India, they take a particular vehicle from a particular person.
Fine.
All these Oil India, they take
You have to keep
that
the
1
number.
month we are taking this vehicle. This is a right to use.
In fact, in ONGC also, my lord, if I remember, my lord, this was there. They provide this number and not while quoting the people.
No. That is a
Okay, but-
number is different. This is required for the entry. That is not
Part
specific
of the
to that.
agreement.
No. Because
Yes.
number is required. Because this person very well has to enter.
Right.
You may not allow.
Right.
But there might be a term out there where if a separate number is there, has to, another vehicle is placed for sale. Another. So it is not a vehicle. It
Right.
is
Service. Well, and
what do you say? GST. That is what is the concept of right to use. Hello? Hearing, I heard in part, We'll have the time,
Anything convenient, but I hearing
15 at the top of the list. No further attainment.
Important fact.
These also. Study.
Lord, this is pertaining to section 148.
There are two writ petition, Lordship.
Eh?
There are two writ petitions.
Study.
One is of 21
Income tax.
income tax,
Okay, hi. 148.
148.
This is as per the 2021.
Lordship, in my humble submission, 21 is written in process in view of the Ashish Agarwal.
Huh?
In view of the Ashish Agarwal judgment. Probably this the writ petition is given in process. Second one, we have to notice. Their contention is that it is part by limited. They challenge the maintenance.
But we'll have it come with a lot. It gets to the learned counsel for the petitioner. Matters that it. Bad. I give you the liberty whenever you feel like.
Next week,
No, next week.
last week of February.
Huh?
Last week of February.
After. I hope that by that time your senior will be there.
Yes.
Much.
On 19th of.
Take
Then get repeat. Yes, what is this?
But in this case, your lordship had called for the record of from the Board of Revenue. Now, in the Board of Revenue record, it appears that the order of the record from the circle officer and the ADC has been transmitted back by the Board of Revenue. So those two records are also necessary for.
What is that order passed? What order? Is it the order?
Yes, your lordship's order is there. Where your lordship had called for the revenue appeal
2020.
from the Board of Revenue.
Taking it to the area. Okay. Now let us see what is the ground. What is your ground?
Lordship, my grounds are in page 13, your lordship. There are 9 grounds in total, but there are 3 important grounds, your lordship. First ground is the cancellation of earlier agreement does not wipe out the irrevocable power of attorney. Second one is the learned revenue board assume all the power of civil court, your lord. And the third main ground is revenue board jurisdiction was only to examine the property was validly transferred or not to go beyond that.
Is the
Validity of transfer.
Filed by the mutation order. Who was the appellant?
I was that.
You. Yes, tell me what is your case?
Lordship, in this case, my power of attorney holder has executed a deed in favor of his wife, transferring a property belonging. Now, while doing so,
Property belonging to you.
yes, me and my minor children at that point of time who has appealed. Now, no notice was issued by the circle officer when such a transaction was done.
What
Notice by the
selling?
for the selling from the circle officer when the mutation was placed by the purchaser, seeking.
No. But who had given a power?
Yes.
To some. He had it.
He has executed a sale deed on the basis of the power of attorney in the favor of his wife.
Now,
Now-
have you challenged the sale?
Pardon, Your Lordship.
Have you challenged the sale deed?
No, at that point of time, we did not tell it when the order was filed.
Have you challenged the sale deed as of now?
No, nothing. Now, what had happened is the power of attorney which was given was with regard to our agreement between the builder, the power of attorney holder is the builder over my property. The builder was given a power of attorney on the basis of an agreement between me and the builder, which was subsequently cancelled. And a fresh agreement was entered, and by that fresh agreement, the earlier power of the earlier deed was totally specifically stated that it no longer exists, and this present deed will be there. Now, there was no condition with regard to the power of attorney in the second. So the earlier deed, which was the power of attorney, which was granted, was solely on the basis of the earlier agreement between me and the builder. So our contention was that this sale deed, no notice was issued while the mutation was filed by the purchaser, that Nina Juria, who is the appellant or the petitioner before your lordship. And her petition was filed taking her name to be mutated. As per the norm, notice is to be issued to the other patadar, which was not done in this. A document was purportedly given with regard to the processor. We disputed that when we came to know about it, when we appeared before the ADC, our appeal was heard. We pointed out that the signatures are
First
not
of all,
our.
it's a first that better right and right.
Pardon,
As your right in respect to the land being sold by the sale deed.
yes, sir.
No, no,
Because-
you have not challenged the sale deed.
But the process,
Whatever the process, mutation is only for the purpose of collection of revenue, nothing more than that. Here is a case where you have not challenged the sale deed, so under such
that is at that point of time,
the
we not
right
done.
in respect to the land has already been transferred.
We have
you
not
are in
challenged it at
possession.
that point of
Are
time.
you in possession?
Yes, Your Lord.
Their possession was granted to him by the
Power of
circle of.
attorney. Power of attorney. So you have to challenge those
I-
sale deed.
I understand that.
Without that, nothing is made. That's it. You set aside this thing. That's your please
Yes, Your Lord.
set aside this. However, you file this, then that will be subject to be filed. Isn't it? What is the ground on which he has done that?
The ground.
On the ground
Board
that
of
it was
Revenue
not
came-
given. All notice was not granted.
Yes, no, notice it was there, but the main ground, the tribunal Board of Revenue came to the finding that the power of attorney on the basis of which
He has the business. Power of attorney. And why do we require the record? Not required. Good.
that the notice, that part is remaining, that part was not considered.
Which-
The notice, the process of the,
That is not necessary. See, first we have to have a right. Isn't
Yes.
it? To challenge a mutation.
Yes.
You have to have the right. And your right will only accrue if the sale deed is put to challenge.
understand,
So without challenging the sale deed, nothing
that
remains.
part is there, the council engaged there did not challenge it, he filed a revenue.
That is the biggest problem. They find it easier to move the revenue than to go to the.
That part was totally skipped, the civil jurisdiction was not passed.
Now the sad part is you may have lost out on the limitation of
Because that, when it came to me, it was already,
it was already dead. It was only present to the primitive.
already the statutory parts are over, your lord.
Yes, it's the end of the what you have to say.
Another point was there, Your Lordship, in the sale deed,
You were the owner of the
we are
land.
the owner.
You were the owners of the land.
Yes.
5, 6, and 7. You gave a power of attorney and an agree to the builder.
Yes.
Along with entered into an agreement. That agreement was thereupon revised. And you come up with a new agreement. But the power of attorney remained intact.
They did not touch upon the power of attorney.
Understood. Now, once that on the basis of that power of attorney, the sale had taken place. Now, thereupon mutation was done.
Thereupon mutation.
And you challenged the mutation on the ground of section 50.
Non-service of notices.
Section 50, non-service, which is 1 month notice. And thereupon, this AR was cancelled.
No, thereupon, the first, the ADC gave the thing in their favor. Then on against that.
So
came
the
before-
mutation circle officer did not. So they filed an
Circuit
appeal.
officer granted the thing in their favor.
Ah.
Thereafter, when we came to know about the passing of the order, we challenged it before the ADC. The ADC also upheld the judgment or the direction of the circle of.
And then you went to Board of
Then we
Revenue.
went to the,
Board of Revenue,
granted in our
your-
favor.
the instant writ petition has been filed by the petitioner challenging the judgment dated 10/9/2021 passed by the learned Assam Board of Revenue in case number 83 RA bracket K oblique 2018. The facts involved in the instant case, as would be discerned from the pleadings as well as the documents on record, is that the respondent, private respondent number 7, 8, and 9 were the owner of a plot of land measuring
Profit.
owner of a plot of land measuring 2.58 hours in tag number 187 of KP Pata number 241 of Kohor Part 3 under Moja, Guwahati. Owner. Who was the owner? Respondent number 6.
Yes,
The respondent number 6 was the
means after the demise of the husband of the respondent number 6.
then 5 and 5, 5
Sorry,
and 7 come.
respondent number 5. Chandana Kalita.
No, respondent number 6 died.
No, Vishwajit Kolita is the daughter, son of Chandana Kolita.
Now, who is the respondent number 6?
Respondent number 6 is Vishwajit Kolita.
Who is the owner of the land?
Chandana Kalita, Vishwajit Kolita, and Hina Kalita.
Then why the registered power of attorney was given by one?
Because at that point of time, the other two were minors.
Okay.
He is the mother of the respondent number 6 and 7.
How can you be a minor? I be a minor?
It is stated in the deed, Your Lordship. That is what I have come across.
No. Kindly see. See the name of the party. 5.
Yes.
Srimati Chandana Kolita, wife of Dinesh Chandra Kolita. How can you be a minor? And if 6 is the owner,
She is the mother.
so therefore she is not a minor. Then who
No,
is
no,
the
not-
owner?
Chandana Kolita is not the minor. I'm saying Vishwajit Kolita and Hina Kolita.
But the power of attorney was entered into by the respondent number 6.
The power of attorney, I think it was by Chandana
Chandana
Kolita.
Kalita, Vishwajit Kalita, and Srimati Hena Kalita.
No. Kindly see. Hey. Okay. It has been wrongly mentioned. But the respondent number 5 and 6 and 7 were the owner. Because the said respondent entered into an agreement for development of land with one Ashok Kumar Juria. He's a party.
He is
Yes,
a party
Lord.
petitioner number 2.
with the petitioner number 2 for development of the land. The said deed was registered and numbered as deed number 1039/05. By another registered by an registered irrevocable general power of attorney. The respondent number 5 and the respondent number 6 and 7, who were the minors at that point of time, through their mother, empowered and nominated the petitioner number 2 as their power of attorney holder, as their power of attorney. In respect to the said land measuring 2.58 hours, in the said power of attorney, amongst others, the attorney holder was empowered to sign and execute the transfer deed, and in respect of the share of the attorney in the scheduled proportionate schedule of land and the RCC building, and get the same registered before the sub-register Kamrup at Guwahati and put in possession thereof. Subsequent thereto, another deed of agreement was entered into by the respondent numbers 5, 6, and 7 with the petitioner number 2.
And clause 20 is the one which overrides the earlier. Page 38.
Whereby fresh terms and conditions were incorporated and the earlier registered agreement for development was cancelled. Full stop. What is this deed of lease?
Pardon, Lord.
This deed of lease is executed between me and him, the owner. The owners have leased out the property to me for 9 years.
Not really.
That is a separate case is pending for eviction. That is
The record for the reveal that the petitioner number 2, thereupon, on the basis of acting on the basis of the power of attorney, registered power of attorney dated 4/2/2005,
Your Lordship, if I may just say, the power of attorney in the sale deed does not tell you this was one of the grounds by the power of attorney, which is referred in the sale deed, does not tell you with the deed number of the power of attorney we had done. This was one of the grounds we had taken in the
okay, petitioner number 2. Oh, no, the record for the reveals that the petitioner number 2 executed a deed of sale in favor of the petitioner number 1. Thereby transferring the unfinished commercial space measuring 130.61 square meters on the ground floor and 173.20 square meters on the first floor. In total, 3269 square feet, bracket close, together with 1.70 R land and the entire parking space on the ground floor, which is situated by the side of the HB Road, Omorpati, and standing on a plot of land measuring 19 letters covered by dark number 187 of KP Patra number 214 of Sohar, Guwahati, Part 2, under Moda, Guwahati, in the district of Kamrup Metro, to the petitioner number 2, 1. By the registered sale deed bearing deed number 1226/2012. By the registered sale deed dated 13/2/2012 bearing deed number 1226 of 2012. On the basis of the said deed of sale, the petitioner number 2, petitioner number 1 applied for mutation before the circle officer. On the basis of the said application, a mutation case number 1379/2012-13 was registered, and by an order dated 11/3/2003, 3 or 13? 13.
13.
It
13.
should be 30.
13. The name of the petitioner number 1 was inserted along with the patada in respect to the plot of land measuring 1.70 R covered by dark number 187 of KP Patta number 214 of Sohar, Guwahati, Part 3. The record further reveals that a deed of rectification was executed. Registered deed of rectification was executed by the respondent numbers, private respondent number 6, 5, 6, and 7, bearing dated 25/5/2015, bearing deed number 6008.
That is the point, Your Lordship. If Your Lordship, it has been signed by the power of attorney holder. It has not been done by us.
2. The petitioner number 2 thereby making a rectification to the deed of sale bearing deed number 1226/2012 dated 13/2/2012.
And this was done after we had raised an objection saying that the deed number of the power of attorney does not tally with the circle office. And after the order of the circle.
In the mean, the said deed of rectification, it will take a look. Thereupon, it revealed that the private respondent numbers 5, 6, and 7 had filed an appeal before the Deputy Commissioner,
Yes, it was the DC. It was heard by
Kamrup
the
Metro. Kamrup Metro,
department.
Deputy Commissioner, Kamrup Metro.
Yes.
Deputy Commissioner, Kamrup Metro, challenging the order of mutation dated 11/3/2013, passed in mutation case number 1379/2012-13. The said mutation application, the said appeal, however, was dismissed. The said appeal, which was registered as Revenue Appeal number RA/M number 9/2015-16, was however dismissed by an order dated 27/9/2018, thereby confirming the mutation order made by the circle officer in favor of the petitioner number 1. Being aggrieved, the private respondent number 5, 6, and 7 challenged the said order dated 27/9/2018 before the learned passed in RA/M number R9/2015-16 before the learned Assam Board of Revenue, which and the said appeal was registered and numbered as 83 RA/K/2018. By the impugned judgment dated 10/9/2021, the said appeal filed by the private respondent number 5, 6, and 7 herein was allowed, thereby setting aside the order dated 27/9/2015 passed by the additional Deputy Commissioner, as well as the mutation order dated 11/3/2013. It is against this order dated judgment dated 10/9/2021 that the petitioner has approached this court by filing the present petition. This court have also perused the records which were called for by this court by the order dated 17/10/2021, and also heard the learned counsel appearing on behalf of the party. During the course of hearing, this court had put a specific query upon Mr. A. Biswas, the learned counsel appearing on behalf of the private respondents number 5, 6, and 7 as to whether the deed of sale on the basis of which the possession, the deed of sale on the basis of which the mutation order was passed on 11/3/2013 have been assailed, have been challenged in any proceeding before the competent civil court. This court had also inquired with the learned counsels appearing on behalf of the parties as to who is presently in occupation of the same land and the building. The learned counsel appearing on behalf of the respondent number 5, 6, and 7, with all fairness submitted that the deed of sale bearing deed number 1226/2012 dated 13/2/2012, as well as the rectification deed dated 25/5/2015 bearing deed number 6008/2015 have not yet been challenged before the competent court of jurisdiction, so competent civil court. As regards the question of possession, it has been admitted that petitioner number 1 is in possession of the property in question. It's partly in possession of the property.
On the basis of the sale.
On the basis, the partly is in possession of the property in question to the extent of land, to the extent the property has been sold to the petitioner by the deed of sale bearing deed number 13, bearing deed of sale dated 13/2/2000. Because half is so. But
Means 3+1 portion has been given from the ground.
no, that land is, there was only 2% item. Half is yours. It's 50/50, it is that. 2.85 is there.
Yes.
Total, of which 170 is.
Has been given by the power of attorney holder.
So why are you fighting all this time?
Because
They won, or they have too much of money for fighting
the
litigation.
thing is, your lordship,
Anyway, we'll
the
hear
petitioner
later.
number
and
2 is in
let me
possession of
finish
the
up
entire
before
land, your
1 o'clock.
lordship.
Yes. He is in possession of the property to the extent which have been sold by the deed of sale bearing deed of sale dated 13/2/2012. The above two aspects therefore makes it clear that by the registered deed of sale, the property in question, including a portion of the land, including the proportionate interest, proportionate share of the land, that is 1.70 Rs, have been sold to the petitioner, number 1. Until the sale made to the petitioner, number 1, remain. The petitioner number 1 is the owner of the property as conveyed by the deed of sale dated 13/2/2012. Further to that, as the petitioner number 1 is in possession of the property which have been sold by the deed of sale dated 13/2/2012, and the requirement for mutation is to have title as well as possession, which the petitioner duly has, number 1 has. The it is the opinion of this court that the learned Board of Revenue had erred in law, had committed an error apparent in law in passing the impugned judgment and order, judgment dated 10/9/2021. Accordingly, this court therefore sets aside the impugned judgment and order dated 10/9/2021. The registry is directed to return the records to the learned Assam Board of Revenue, records of a RA case number 83 RA/2018 to the learned Assam Board. Before concluding, this court, however, finds it relevant to observe that the mutation so granted is on the basis of the deed of sale dated 13/2/2012, registered deed of sale dated 13/2/2012, and as such, till such deed of sale is not set aside by a competent court of jurisdiction, the mutation order of the petitioner, number one, cannot be interfered with.
Though I cannot, but I request you, because the limitation from the date of knowledge has already expired. So it's a liberty because maybe
Liberty for what?
for challenging the sale deed, your lord.
Oh, let me go to general elections. If I get a ticket, I will fight it out. Let me become a
Because-
parliamentarian and let me fight and change the limitation law. Like, yes. How can I give the limitation, extend the limitation which is not there
Because
unless you amend it?
the
We have
limitation was
to come up with an
already
amendment.
overwhelmed. As I lord,
It is at your behest.
WPC 1466. Now, this was the order by which, my lord, my technical bid was rejected. You were rejected on ground number one,
Page
page 134, madam.
134.
Yes.
Oh,
It's
sorry,
a WhatsApp message, madam. Yes. You were rejected on grounds cancel court fee not found. That is number one. A notarized affidavit on ₹100 non-judicial stamp paper about minor mineral held by the bidder and no mineral due to the government of Assam not found. So my technical bid was rejected primarily on these two grounds. One, cancel court fee. It was not done. Court fee was not. And secondly, my lord, that notarized affidavit on non-judicial stamp paper about minor mineral held by the petitioner and no due to the government was not. My lord, against this, my lord, we approached this honorable court, and this honorable court, my lord, passed an order whereby, my lord, they were asked not to proceed with the tender. That is WPC 3394 of 2021. In the meantime, what had happened, my lord, the order to If your lordship will kindly have the order dated 29/7/21, my lord. Last para. Till the next returnable date, tender process in respect of the Krong Sand Mall. By the auction notice issued under provisions of Assam Central shall not be processed and shall maintain a status quo as on 26/7/21 in that respect. Yeah, that was it.
Till 26 7, 2021,
Ah.
there was no, the second round was not on it.
Then, my lord, that order was subsequently extended. Now, in the meantime, my lord, what had happened? The state government itself came up with a stand that there is something wrong in the tender process. Sorry, MTRON, my lord. And the letter is at 135. It's a communication dated 27/7/21. If your lordships will kindly come to page 137. Last para. Under these above circumstances, MTRON would like to suggest that the current e-auction should be cancelled and restarted with proper NIT document for benefit of all bidders. The NIT document should be corrected as required so that it is in line with online e-auction system. Further, you may request us for necessary training for the stakeholders, including dealing assistant and senior officers. So MTRON was the agency to whom this work was outsourced, my lord. They themselves came up with this suggestion. Then in that proceeding, my lord, 3394 of 2021, an order was passed by this honorable court on, my lord, 13/6/22. Kindly see the, my lord, submission of the state at page 142. First last line sentence. D. Gogoi Lanet Standing Counsel, Forest Department has appeared on behalf of the official respondent and submits that since there is already a recommendation from Assam Electronic Development Corporation for cancellation of the tender in question, the State Forest Department authorities would abide by the same. Consequently, the tender is in the process of being cancelled. So, my lord, taking note of this submission, it was ordered. If that be so, Mr. Gogoi is directed to take steps for filing an affidavit to the competent authority, bringing on record the final decision on the question of cancellation of the tender. Let this writ petition be listed again on 22/6/22. In the meantime, affidavit shall be brought on record. Then, my lord, the order was followed by page 144. This order dated 22/6/22. May I have your lordship's kind attention to page 147, last sentence. Mr. Pathak Dilanet, Standing Counsel, Forest Department, submits on instruction that though no final decision has yet been taken regarding cancellation of the tender, in view of clause 8, 13, and 18 of the tender document, the departmental authorities would be open to revisit the matter upon physical verification of the documents to be submitted by the writ petitioner, if such a directive is issued by this court. And last but one para, since the tender document contains clauses which permits recourse proposed by the departmental authority revisiting the technical evaluation, and since all the parties are agreeable to such a direction, I dispose of this writ petition by providing that within 2 weeks from today, the official respondents may take steps for revisiting the decision of the technical evaluation committee after physical verification of the hard copy of the document relied upon by both the petition. My lord, based on the concession given by the standing counsel, this honorable court gave an opportunity to the department to take resort to clause 8, 13, and 18 and revisit the technical evaluation. Now, may I have your lordship's kind attention to the clauses which permits re-evaluation, my lord. That your lordships will find at page number 52. Now, 52, this is the clause, my lord. Page 52 is that particular clause.
Here they have mentioned 8, 13 and 18.
Yes. At page 55.
55.
Yes. Somewhere, my lord, in the middle, the sentence starting with the technical bid and initial price offer, as a lordship got it. The technical bid and the initial price offer must be submitted electronically as provided in Schedule 2. Failing which technical bid shall be deemed to be not received. The duly executed original physical copy of the technical bid may be demanded by the authorities at the address specified in clause 13.1.2 anytime during the bidding process. In case of differences between the documents submitted electronically and original documents submitted physically, the original document submitted physically shall prevail, earnest money shall be made electronically according to the details provided. So, my lord, there is a scope of demanding the original copy of the bid and make a comparison, and in case of any difference or
The
then the
original.
original will prevail. Then my lord will kindly come over to the next page, my lord.
But what happens as regards the digitally signed document?
Yes, my lord, only infirmity in our tender was, my lord, instead of work number 4, we gave both, in both the cases, we gave 5. That was the
No.
only.
That's
a minor deviation.
That is not relevant.
Ah.
But what happens as regards a digitally signed? If it is a digitally signed document,
Yes,
as per the Information and Technology Act,
yes,
you can download it.
Yes.
The moment you are downloading it,
yes,
it loses its efficacy.
yes,
If it is to be filed electronic,
Yeah.
and as per the Information Technology Act, you can submit it digitally also.
You
can sign it digitally.
digital. In
Now,
fact, we did
once
it.
you submit it digitally,
Hmm.
you can't download it.
No, normally, my lord, what do we upload? The scan copy of the original bid. So, in the, my lord,
No. You upload scan copy. Yes, there are certain things like, just for example, the bank guarantee. You will upload, or the earnest money, the check or whatever maybe, you will
we'll
upload
scan
it by
and upload it.
upload. But as regards a document, you can sign it digitally.
Yes.
So once you sign it digitally, as per the Information Technology Act, you can't download it. It has to be kept out there in a digital form. Then how do you take care? How do you have a physical copy?
No, original copy I am retaining. No. What?
Original copy you can't digitally sign. It has to be only on the computer. It has to be digitally signed.
No.
Yes.
Huh? The original. No, my lord.
Why I'm saying is, I know this process because we had a big problem as regards the certified e-certified copy.
Okay.
Now the e-certified copies, if it will be given, it has to be digitally signed. You see, there is a difference between a scan copy and an e-certified copy.
Okay.
Just for example, I have today the power to sign digitally. Although I do it by my hand, but I have a digital signature. So the moment I put that, it is done. But the Information Technology Act also says that you can't download it.
Okay.
It will remain out there. Therefore, that was the main issue when we were discussing on the e-certified copy, that has to be used out there in the computer.
Yes.
So,
well, eventually in this case, now there are third round. This is the third round of litigation. Now, what they have boiled down to, now they could not find any other fault. Now they say that in the number was wrongly put. That is the only.
No, there is another reason. That is why I'm asking. The physical copy, they are saying something about the physical copy.
No. Now the eventual impugn order is at, my lord,
page 166.
Yes. No, at page 168. 168. It was found that the document of fixation of court fee stamp bears auction number 5 instead of 4 for Dikrong Also, they failed to furnish signed copies of the original bid document for participation in online auction tender process along with their bid.
Hmm.
Secondly, he failed to sign the original bid document and submit the same in online as well as physical mode dated so and so. Therefore, bid of Ajit Bora cannot be accepted for the reasons above.
So this is the reason
Yes, this is the
on
final
which
reason.
we are
Ah.
today. As regards the first thing, this court will take care of.
Ah.
But what about the other two?
Ah.
Is that they failed to furnish the signed copies. But
Ah.
before that,
Ah.
this is one aspect. Now, as I could see from Justice Shyam's order, the first order,
Ah.
the technical evaluation was done and the going to the second stage was stopped.
Yes.
It went on, and thereupon the court directed that you take note of all these physical copies,
Ah.
and thereupon you
Take a call.
take a call. Now, what happened thereafter?
That exercise was never undertaken. What do you say?
No, therereupon what happened?
Yes,
Why the
I'm coming
second order was,
factually, my lord. Yes.
there is another order.
Then, my lord, what happened? They passed an order at page 150, 150.
Yeah. What?
Please come to 153. This, my lord, triggered the second round order. In the light of the above observation and finding, and after careful examination of all records and documents, it is found that the claim of the two bidders, namely Ajit Borua and Lakung Ragia, for accepting their technical bid on grounds that they have submitted the correct technical bid in all respect is not a matter of fact and is not valid. Therefore, in view of the above, DFO Lakhimpur Division is directed to continue further with NIT dated so and so of bidding with qualified bidders, namely Ganesh Kalwar and Ranadev Saikia. Now, we put to challenge this order, my lord. There, this honorable court passed an order, which your lordships will find at page 155. And the operative portion
And this
is
order
that
was, this was done on 28/6, 2016.
yes.
Yes, then
Now we put to challenge this order at page 157 is the operative part of the order. Somewhere in the middle, D. Gogoi Lanet Standing Council, Forest Department, Assam submitted in his usual fairness that the impugn order does not appear to be in consonance with the direction passed by this court. Lanet Departmental Council, however, praised for the posting this matter again on 8/9/22 so as to enable the department to take a corrective measure as may be permissible under the law. Then on next date fixed, Lanet Departmental Council to apprise this court as to the basis on which the impugn order has been issued. So,
and
my lord, there was a concession by the departmental council that earlier directions were not complied with. Therefore, my lord, this order was passed.
so thereupon on 159 page 8,
Yes.
order-
159, they kept the tender process in abeyance.
26/8/2022
Yes.
has been kept. No, you see the
Yeah.
wording out here. The speaking order dated so and so
Ah.
is kept in abeyance.
Yes.
Then
Then, my lord, that the present, then we instituted another proceeding. Then, my lord, in 5732, another order was passed. It starts at 160. At 163. After hearing all this thing, Representative Farza has
No.
appeared and produced the
we are
copy.
still at the first stage.
Yes,
If we are in the first stage, that is why yesterday I was asking it.
Ah.
If we are in the first stage, have not gone into the second stage,
yes.
the only person remains is him.
Therefore, there has to be a fresh tender.
Sorry.
Mm.
In between 154 and 156 is two blocks. Already the second stage has started. on 31st of April.
No, but
Taken it down.
no, but understood. But that very order of technical
Yes.
was kept in abeyance by the authorities concerned at page 159.
159. So 159 when? My lord,
whatever may be,
no,
but
I just point out.
when the authorities themselves has kept that order in abeyance, meaning thereby the authority did not go to the second
No,
stage.
They went, what they have to find, I just try to convey. Between 154 and the matter which was moved by them on 6/9, on 6/9/2022, when only the process started, I'll show it, 31/8/2022. But when on 6/9/2022, an order was passed, then the government realized, and the notification was issued on 7th of September 2023, at page 150.
So therefore, the government did not go into the second stage thereafter.
I could take it forward. In second stage, I have got, at the time when the interim order was passed, this was produced before the court, and I have got a copy. This order, it was put to challenge by my learned client, that is at 154. When they were technically, again, the matter came, authority examined the matter, and ultimately technically it was rejected. Then you see at 154, they said that e-auction was second stage of bidding at page 154, and this is 154.
Yes.
Therefore, in
Directly to continue further, that is the e-auction process of the second stage of bidding with the qualified tender.
Now you are asking whether the second stage they have gone on the authority. Now, with great respect, the second stage they have gone after this order was passed. 31/8, your local can is noted out, 31/8/2020. There were two bidders. So financial bid, determining the financial bid always started on 31/8/2020. On 6/9, they came and challenged this order. By the time financial bid was over. Am I clear to you?
I understand that, but Mr. Das, the fact is, when the technical bid was kept in abeyance, when the authorities said that we are not going to go as per that 26/8, and therefore we will revisit, meaning thereby the technical bid is again reopened.
But today, the financial bid also was not given effect.
We will go to the financial bid subsequently, but the first and foremost is the technical bid which was there was not finalized. Yes, it was done on 26/8/2022. It was done. They challenged it. When Mr. Gogoi said that it was not done in a proper, and on 7/9 says that technical bid of 26/8 is kept in abeyance, and thereupon the authorities themselves say that we are again revisiting the technical bid. Once the technical bid is going to be revisited, the earlier process, if anything was done, has already become useless. You cannot go back there. That is the only question.
Fine, but no, whether they have gone to the second stage on. Second stage.
The second stage. Therefore, I was saying whether they have gone to the second stage. Now, the second stage will only come after the first stage is over.
No, that's true.
But the first stage is not over because on the fact that in the last order itself, they have only considered again the technical aspect.
But why? That's what why learned appeared at told the court on 6/9/2020 that we'll again revisit. But by the time that exercise was done, they realized that there is an order from the court where my learned has given a concession. And on 7th of September 2022-23, there was, or they kept it abeyance. They know because they have.
And then they also, not only that, then they revisited. And there is an order being passed by the court to revisit. So what do you say about this order being passed?
Then they revisited and ultimately they found at page 168, which is now put to check.
Understood. But as of now, there was no as on the date on which they have passed the order on 8/2/2023, the technical bid was only valid with one tenderer.
My lord, kindly permit me, page 166, para 6, everything will be clear. Page 166, para 6. This is the position. That as per the bid evaluation committee report dated 6/7/21, the bids of three bidders, Ranidev Saikia, Ganesh Talwar, and Tokeshwar Doloi were technically qualified. However, Tokeshwar Doloi and Ganesh Talwar has withdrawn their arrangement. So only one tenderer bidder is in the field, that is my lord, my learned friend's client, Ranadev Chaitya.
No, kindly come to number 5,
Yes,
the last line.
yes, on 26/9, they signed copies
No,
of
no,
the
the
physical
last
state.
line. Meanwhile,
Meanwhile, thus from the above, it is seen that 10 bidders
no,
were
no, just
involved in
before
so
that.
and so.
Meanwhile, the fourth bidder,
Meanwhile, the fourth bidder has withdrawn the earnest money.
amount of rupees so and so, and
So-
paid by Mtron on 5/12.
Yes.
So this happened even after that 2018.
So, my lord, only one bidder remains, therefore it calls for a fresh tender without going to anything else. The only one bidder is there in the fray.
Yes. You are the cause of agony. Yes.
Lordship, we would submit that the bidding only took place once. After that, all the revisiting exercise was with.
No, Mr. Bhattako. Bhattako. You can go into the second stage when?
When the first stage is over.
When was the first stage?
First stage is still
Over
going.
when the technical evaluation has been done by you.
Yes.
Even if you have inadvertently or rightly or wrongly gone into the second stage also. But you cannot, after going to the second stage, you can't come back to the first stage. You
Yes.
cannot come back. But if you have come back to the first stage, then the second stage, if you have at all gone into, has become redundant. There's no way out.
But I would say, Lordship, the first stage, as it is, as far as the bidding process is concerned, it was already over.
Forget about the bidding. We are not concerned about the bidding. We are concerned about the 2 stages.
Technical evaluation.
Bidding is over. Bidding is long time over. But the 2 stages are what? The first stage is the technical bid. The second is the price.
Yes.
The first stage is over when the technical evaluation is done.
Yes.
And once the technical evaluation is done, then you can go to the second stage. Now you by yourself have said that you are going to revisit and accordingly revisit it.
Yes.
Even as on 8/2/2023 also you revisited on the technical aspect. On the technical aspect, you could not go together. One has to first complete one stage and the second stage then is over. It is a two dual bid. So 2 aspects has to be there. Once you go back to the technical stage, the first bid has to be taken. Anything you have done has become inconsequential in the eyes of law. And more so, when this court has directed you in the last one, on the basis of your submission, that this court has directed you to make revisit.
But Lordship, that revisiting is only with regard to the eligibility of the petitioner. Otherwise, the process was.
Where is the question of the eligibility? What is the question of eligibility?
Whether
Is
they-
it on the question of the price? No. On the question of technical. So you again come back to technical.
But it is only with regard to the specific petitioners, Lord.
Are you saying that on 8/2/2023, you have not considered the other bidders?
They were already considered, Lordship.
No. Have you
Yes.
not taken into consideration the qualification?
They were all of them were, Lordship, already
Yes,
considered in the first.
Now
round
tell
of
me one
bidding.
thing, just for example. Have you taken the money? Why did you allow the earnest money to be taken out? Why?
Because Lordship, the
Why?
contract provisions of the contract allows them to withdraw before,
Till
before conclusion of the agreement, Lordship.
no, before conclusion of the technical bidders. Once you are qualified out there, can you be allowed? Let us see how the earnest money can be allowed. Let's see the provision of earnest money.
Yes, yes. Yes, yes.
Page 64.
56. Page 56, madam.
Ernest, 14 foot,
Page 56.
65. The bidder shall furnish as part of the technical bid an earnest money deposit as per the procedure given in each bidder shall deposit along with the technical bid and earnest money amounting to as per the rules of where and the said amount shall be 10% of the reserve price. However, bidder deposit a certificate of save and accept as provided in the bid. The earnest money of an unsuccessful bidder would be returned by the state government here without interest as promptly as possible. The lessee contractor bidder share would be returned without interest to furnish the first 30 days. State security to profit appropriate participation as restricted in any of the specified bidders. Valid submitted. See, if a bidder withdraws his bid during the period of bid validity as specified in the bidding document or as extended by mutual consent of the state government authority, then you are to forfeit. Have you done that? It was during the bid validity. How did you permit the other bidders to withdraw?
Lordship, as far as our information is concerned, he withdrew after submitting his financial bid. When he was unsuccessful in the financial bid, because he participated in the financial bid.
The bidding document, are you saying that the financial bid will be submitted later on?
Yes.
No. The financial price bid and the technical bid all have to be submitted together.
No,
Wait.
Lordship, I am talking about since this process was going on and they were, these two candidates were declared already successful, and that position won't be changed by this litigation. Therefore, they were allowed to proceed with the financial bids, and there both of them had participated.
When did he withdraw? On 14/12/2022. How can you withdraw? As on that date, the matter was pending. Now I think the expenses of all the petitioner and the respondents should be taken care of by the forest or which department?
Forest department.
Cost. Because-
We just
give a reply.
No, okay. I'll give you that. But this cost has to be given from them. All happened because of you should have taken a good step. All along you have been your action, whatever you have done. The law council who was representing it is as if it is the council of the forest department of this department was trying to hoodwink this court. On one hand, you come up and say out here that we are going to cancel in view of what Mtron has stated. Then you don't take a decision to that effect. And thereupon you say that we have an opportunity to take in terms with look into under 8, 13, 10 and 13. You take an opportunity to look into those documents. And thereupon you come upon 26/8/2022, this order. When this order comes up on 22/6, you come up and say that it is not in consonance with the order being passed by the court. And as such, we are going to do something. And therefore, the matter which was taken up on 6/9/2022 The matter gets deferred to be taken up on 8/9/2022, and on 7/9/2022, you keep the order of 26/8 in abeyance, meaning thereby you are still acting on the technical bid. Thereafter, you come up before this court and look here, we have now done away with 26/8. Now, once 26/8 is gone, can there be a technical, is there a technical evaluation?
Because
Tell me one thing. If 26/8/2022 is taken away, can there be a price, second stage being gone into? No, the answer is simply no, because there is the first stage, without the first stage, you can't come to the second stage.
in my view, Lordship,
There is no view. This is the view. The third it is what you do, you tell this court. And look here, we are again revisiting it. And on the basis of that, this court passes an order to revisit. And when you revisit, you do whatever. But as on the date when you revisit, there is only one. You allow, yes, there is only one bidder. Because as on 8/2/2023, there was only one bidder. So on that date, you were taking into account the technical bid. You could not have gone into the second stage on 8/2/2023 without first deciding the technical bid. Because his technical bid was again the contention because this court had directed you to look into it. So under such circumstances, as when there was only one bid, you are to follow this. And all happened because of you. You should have said, no, nothing doing, we are happy, we are going to do it in this court, and this court would have passed an order, yes or no, and follow Tata Cellular and all, given you all the liberty. But here is a case where you have to hoodwink this court.
Lordship, what I would submit is that on
You
7/6/2020,
submit on how much cost you should bear on the litigation expenses of the petitioner and the response. Under whose direction or instructions you have been doing all these things? This is the instruction. On one hand, you come up that we are going to cancel it. Whose instruction? There must have been instruction, or is it on the personal aspect? Yes, Mr. Gogoi, you were the person who said that before this court that we are going to cancel it.
I'll
Under
clarify.
whose instruction did
clarify,
you do that?
That part, okay, we should proceed. To that extent, I can give contention. But that contention, that there is only one bidder technically qualified, no, man. There were two other bidders, man.
When?
On that date, my lord, that this speaking order would reveal, my lords, on 15/7/21, my lords, everybody was informed to come and submit.
The concept as on 8/2/2023, you were still considering the technical bid.
Yes, my lord.
On that day, there was only one bidder. That is what is the finding out here. Only one bidder was remained because the other two bidders have failed to pay the earnest money or withdraw. That is your finding. Or is it or is it your case that you are revisiting the entire aspect? That is not the case because from the facts out there, you were still to look into the technical bit.
Closing upon that fact, lordship is correct. But that other contention is coming.
The remaining correctness is for the judgment. And Mr. Chaudhary to put. I'm not going into court. I'm not unnecessarily we have that. So no, Mr. Das, on the first, if they have not come up with all these pleas, we are going to cancel. Secondly, we are going to look into again, revisit on taking into account 8, 10, and 30. Thereupon, you pass an order, rightly or wrongly. It was not.
We never said
They
we are
did
going to cancel.
They did not support that order before the court. And what they did, they said that this is not in terms with the order being passed by this court. And as such, we are going to revisit this. And therefore, this court directed them to revisit, meaning thereby, this court's order earlier passed on 26/6/2022 and again to be followed, which means again, you look into the technical bit And this technical bid was looked into on 8/2/2023 when there was no other bidder. One bidder was there.
That's for it. What I not what is quantity? That's for 154, 156. As there were two qualified bidders, two qualified second stage, so they proceeded. But your lordship, because there is already a speaking order was subsequent on 6/9. 6/9, they challenged the order of the speaking order, where in the meantime they went ahead. On 31/8/2000, that's absolutely that's fine. On 6/9/2022, they came to the court. And they said that we again will revisit.
And not only
But-
that,
but-
then
but
they
that-
again go back on 7/9.
My lord, will kindly see, on that day, he could have said that already financial figures open. Then the position for me would have been better, my lord. Because that proceeded.
Not only that, how did they allow the artist but to look to other person to be withdrawn? Without, when the bid validity period was very much there. How? Without, you have pocketed it as per the term, you have not done. Unless there is some alibi.
My lord, I don't know which date it has been withdrawn.
No, it is there.
Yeah, no,
14/12/2022.
No, that is the date
No.
of payment, madam.
31/8. My lord, will kindly see.
Kindly see this. Paragraph 5, page 166. Meanwhile, the fourth bidder had withdrawn the earnest money deposit amounting to rupees 29,40,000 and paid by Amtron on 5/12/2022.
Malad, that was based on a letter I have placed. madam. This Ganesh Kalwar, Malad, he comes to DFO, writes a letter on 29 October.
Yes. How did you allow them to withdraw?
Because, my lord, purportedly, my lord, we had gone proceeded, my lord, with the
I
tender,
why-
my lord.
I will just give a reply. Why? Because 31/8/2025, that financial bid started, my lord, I was above him. That's why he thought that he's out. That's why he made, I think, application to withdraw the earnest money. That's the whole situation.
But the thing that
Once he.
because what is happening? Otherwise, what is really happening? It is the, I'm not saying anything, but thing is, it resembles a case of cartelization, where a person withdraws out there knowing fully well that
Perhaps, my lord, that,
if it is a case of cartelization, very,
no,
I hope that the forest department, because
no, that would be very far-flung, my lord.
Huh?
That cartelization, my lord, that perhaps, my lord,
otherwise, why will you withdraw?
because,
are
my lord,
10 bidders.
so, my lord, no, my lord,
So kindly see, there are
wrongly-
10 bidders.
my lord has set aside everything, but rightly or wrongly, we proceeded the second bid, second round, financial. So that person was below the beneficiary.
Why did you say before the report of 6/9/2022 that you have already gone to the second page? Then the report that they passed appropriate order. You said we are going to revisit.
That's the, my lord.
6/9.
Hey, so therefore, is it the case where the forest department is trying to hoodwink this court?
No, there was no attempt of hoodwinking, my lord. We will proceed whatever instruction we receive, my lord. We don't make up instruction. We didn't receive it. After all, these are, my lords, these bidding, online bidding, my lord, documents, my lord.
No. Where is your instruction that you are going to revisit on
My
the
lord.
basis of which submitted?
No, my lord, there was specific, my lord,
Telephone-
since, my lord, there was the entire case, entire platform of this, edifice of this case was based on a clause, my lord, where it says minor deviation. And there's a clause when says, my lord, when there's a dispute between the online copies, my lord, there is a provision which says hard copy will prevail. That was the case. This honorable court, my lord, taking into consideration, that was sent to revisit. my lord. That was the case. That was a concern we also gave since the tender.
This court did not. Your another colleague of yours came up before this court and said that there is a power under 8, 10, and 13 to revisit.
My lord.
And that is why, in view of the specific undertaking given that you are going to revisit, this court to dispose it off.
To which they also agreed, my lord, till to which the petitioners agreed. Because we are
There
just fighting.
was the revisiting,
madam.
so they
Yes.
have done.
Yes.
Revisiting means what? Revisiting again on the technical beat.
And my lord, that bottom part, my lord, already 10 persons were there, 7 were out. petitioners were in that batch of 7. Three numbers are already in. What you will see 148. There were 7 numbers of persons, technical bidders, who were disqualified or technical.
Where is the petitioner among the 7 at page 166?
My
Where is the petitioner?
And then, my lord, this 26-8 order was passed, which
That is gone.
that is gone. I don't.
Look. Yes,
My submission. We have.
I get your submission. Your submission is there. It's okay. This was directed them to a in a particular manner as per the order of the chapter.
Yes.
Therefore, they carried out on 28,000. Correct. And therefore, the petitioners approached 9,000.
6-9.
But in the meantime, they have already opened the second.
Correct.
And as such, the question of the technical deed, not the second stage being not received. And at that relevant point of time, there were 2 bidders and as such,
Absolutely correct. Right. Absolutely correct. And why not 6-9-2022? They could not have said that we'll revisit it because already that part was over.
therefore, they should have paid the date before the.
No, why? No, why this notification was 7-9? Because when they have given undertaking to the court on 6-9, that they will revisit, then they realized that the 7th of September, September 2023, they kept it event. Because undertaking was given to revisit. Now the position, my lord, today, suppose technically, they have, my submission will be technically, they have revisited. They kept their financial gift in abeyance because they couldn't. Because there is an undertaking which is given, by then they will revisit. Now, my lord, for a moment, suppose they have revisited, technically they are disqualified. Then what is the position, my lord? Your lordship will always also write to the extent, what is the sanctity of that financial gift? Because if you have given undertaking to the effect that revisit technical bid, that part goes. Now I am putting another question, putting a question on myself, giving an answer. That technically, my lord, after the order was passed on 6-9-2022, they said, authority said revisit. Again, they revisited. Technically, my lord, they found disqualified.
No, because that is the.
Then what happened?
On 6-9-2022,
Yes,
it is the specific submission of Mr. D. Gogoi
correct.
at page 157
Yes,
has submitted in his usual fairness that the interim order does not appear to be in consonance with the direction passed by this court. The learned departmental counsel, however, prays for putting the matter so as to enable the department to take corrective measures. See the word corrective measures
yes,
as may be permissible. So therefore, they say that the order which has been passed on 26/8/2022 is not as per the direction of the court. This is a topic.
Yes.
Then the
7-9.
they keep the order of 26/8 in abeyance, meaning thereby the
26.
technical bid.
Right.
There is no technical bid. What is the effect of a stay? It is now that technical bid which was there has been eclipsed as of 7/9/2022. We have to take it in the consonance of a stay. So putting it in abeyance is only to that effect. So as on that date, there was no technical bid. It is eclipsed, not gone, but it is eclipsed. 26/8/2022 is eclipsed. Now kindly see at page 163. If that be so, it is apparent that the department is in the course of correction and has now decided to pass a fresh order, meaning thereby now the department says the eclipse which was there to the order of 26 is removed and that no longer remains, and now we are good on the technical. So whatever has happened,
No, I'll just put it this way, the logic participant. If on 159, the notification with the office order which was issued, and they have kept in abeyance,
Because why they kept in abeyance? Because of 6/9/2022, where they've done undertaking before the court. They want to revisit. Correct, my lord?
No,
Eh,
no, they don't care. to
No,
revisit
they
it
said,
on 6/9.
on,
They say
on
that it
6,
is wrong.
no, they said issued by some, they have neither revisited the earlier order.
Revisiting the earlier order is highly people go, what does it?
The legal learned so has submitted that usual panel the impugn order does not appear to be in consonance with the direction passed by this court. Correct. This is one. The learned department, however, praised for posting this matter so as to enable the department take corrective measure as may be permissible under the law. So now, my lord, the technical bit which was already passed by this honorable court. Now he said, no, we have to again go forward for the fresh technical bit. Now, what is the effect now? The effect that they have to go again the technical bit, but they kept at page 159, my lord, they kept in abeyance the order of the earlier order. Earlier order means 26/8/2022 was kept in abeyance.
Therefore, at that relevant point of time, 26/8/2022 was available, as well as your financial constitution was available.
Right.
That is available. But thereafter, what they do, this court passes an order. Now, kindly see what this court says. Category. If that be so, it is apparent that the department is in the course
Which,
of
my lord,
correction and
which
has
one?
now decided.
Page
to pass a
163.
fresh
163, yes.
order. 163.
Yes.
Pass a fresh order, meaning thereby that order of 26/8 no longer survives. Once it has gone, the financial consideration, the financial bid which was looked into,
Whatever,
has also.
My lord, can I just put in this way, my lord? Subject to what your lordship decide. Can I put this way? The order of that order gone to the extent of technical bid. But so far the financial bid, which already has started on 31/8/2022, they knew it and they was kept in abeyance. That's my submission, my.
It reminds me, Mr. Das, I saw this particular. My God,
Oh my,
someday,
oh my.
there was one sheep. There was a person who was a sheep. He was sitting out there without anything down below. So it was found that he was standing actually on a stick, but you don't have that stick there because of the fact that without the technical bid, there cannot be a price bid.
No, once, my lord, the
will be
whole
hanging.
problem, my lord, the whole problem started because 6/9/2022. Because if 31/8/2022, if they would have stated that already financial bid was over.
They had.
No, that's what, now,
He did not submit there.
correct, I understand, my lord.
That is the problem.
So only my submission to the effect is only to the extent, that's your lordship will kindly look into it. Only to the extent of technical bid that is gone. Again, they went for re-examination of a technical bid. Not technical bid, re-examination of the technical bid. Financial bid, my lord, that was kept because they could not. Suppose tomorrow, my lord, let us see 8th of February 2023. If that order, let us put this
The
way.
wording used by this court, fresh order,
No, correct. If
meaning thereby that order of 26/8 is gone.
no, only, but that, my lord, only to the technical bid. Financial bid, of course, your lordship, once technical financial bid, what remains in file. But on 8th of February 2023, my lord, my submission would be, my lord, only to the extent of technical bid was examined. And it was found that they doesn't qualify even on technical bid. So now what is that? If, my lord, let us now say that if technically they would have been qualified, if technically they would have qualified, then my automatically financial bid would have been gone. If technically they would have qualified, then my financial bid would have gone. Then all these bidders will come up and the second stage would have started. That's my submission before your lordship.
There, it court had said that time it's not the case. This court directed the pass of price order.
Right. My lord, that is why.
Meaning there was the earlier order.
No, that is why earlier order.
And as such, this held it, I think it has some infractual.
No, that is why, my lord, the court held it because court also not aware because of the financial bid that was opened on 31/8/2022. No, my lord, let us say the financial bid was open. Court is also,
Mr. Garg, look at that, given the fact that the forest park, so whichever they are, they have not indicated that they are not stating out here that we have opened the financial bid.
but why
What
I'm
they
saying,
have all along said. That is why I use the word this correct.
because why I'm saying,
Taken this for right.
my lord, why I'm saying that, because on the day when an interim order was passed, they came and they submitted before the court that already 31/8/2022, my lord, already financial bid was open. Then my lord will kindly see that interim order. Then their protection was given. No final order will be issued. No final orders will be passed. In the meantime, we can go ahead with our plan and everything, but no final order till it is being decided by this court. Because court is also aware of it 31/8, because they thereafter they came up with 31/8/2022. My lord, what I am just my submission is that what would have happened on 8/2/2023 if this would have gone in their favor? Technically, they would have been qualified. Then the position of the financial bid goes.
Then they have to take it.
That's what I'm saying. They would have gone.
Everybody think financial.
If that financial bid goes, my lord, then because they are also partisan, I am also partisan. But today, as on date, even they are technically disqualified. The last quarter. So if your lordship looks into it, technically where they are qualified or not. But suppose today, my lord, technically your lordship finds that no, technically they are qualified. Technically they are qualified. Your order itself is wrong. So financial bid automatically will go.
That particular clause out there, there no bidder.
I'm sorry.
There is no bidder at the
Yes.
stage of the technical bid.
Yes.
Only one bidder survives. You can't go to the second stage.
Can I just give an answer, my lord? The lordship permits me. On 26/8, before they came up before this court on 6/9/2022, there was, with great respect, my lord, that's what, my lord, there's order passed that there are bidders. There were 2 bidders or 3 bidders before that. So that's why they started with the second stage.
There were 2 bidders.
2 bidders. There were 2
As
bidders.
it apparent from the 26th order.
Yes, there were 2 bidders.
Quarrel with that.
Yes.
There were 2 bidders. As it apparent from that. But the question is, that order is no longer
No, that's
there.
your lordship is, because your lordship is saying, because on the date, when the order of 8/2/2023
I have
was,
understood as on 8/2/2023, when the order was passed, there were 2 bidders. The one which have been allowed to be withdrawn without deducting the earnest money. If that person would have been there, the question was not right. But here is the case, if we go by the tender conditions, there is no other people. All are technically disqualified except two. We are to conclude that 8/2 is the order by which the technical bid was
technical bid, yes, because of the direction of the passed by the court, you have to go to technical bid. So technical bid, they have gone to technical bid. Technical bid also, it was not defective, my friend. They took the stand as it is.
Okay, Mr. Chaudhary,
My
what
lord,
do you say about the other two grounds? That the 40,
prima facie. My lord will kindly come to page 79.
Yes.
Kindly see towards the bottom. Ajit Borua digitally signed. Up to my lord, page 79, my lord. It starts my bid up to page 129.
But then
These are all digitally signed. And this is the downloaded copy, my lord.
it is the downloaded copy.
Yes. So each and every page bears signature and time also, my lord. And regarding the, my lord, second ground, please come to page 68. My lord, they're doing this at the dictation of somebody. Page 68, my lord. B, towards the bottom. B, the bid letter must be signed by a duly authorized representative of the bidder in case the bidder is a company. In other cases, bidder must personally sign the bid letter. Page 118. Huh? And page 118 is my letter, my lord, which I have signed. Please come to page 118. Since I'm an individual, I'm required to sign this letter only. Bid letter which I have signed. So both these grounds are, my lord, based on, facts which is not correct.
They take the copy of original document.
In fact, my lord, going by this,
Now, did they ask for, did they call for the original bidding document?
no,
In the,
no.
but there was a direction being passed.
Yes, no, it was not done, my
Huh?
not done.
There was a direction.
Because the 26 said this impugn order at page 160, 8th of February order reveals that, my lord. Otherwise, they would have indicated.
Now, there is a direction by the court on 8/9/2015
Yes.
that the petitioner shall submit hard copies of the bid document or to be relied upon by them. The court of court.
That we have given, that we have submitted.
That we have, my lord, but it is totally contrary to what has been submitted, my lord. These copies don't contain any kind of digital signature. And that too it was, my lord, signed by Ajit Borua, the petitioner. with
Original
a seal
digital
cover, my lord.
nathake na. In original, there will be no digital.
And also not digital, my lord, the other signs.
Page 79 to 132. এখন তো original, এখন তো sign. Only letter from there.
What do you require?
My lord. My lord,
What is
that,
not there?
my lord, that auction, my lord, stamp BS auction 5 instead of auction 4.
Forget about the auction business. I'm considering.
Signed copies of original bidding document, my lord.
Huh?
Signed copies of original bidding document.
Then
They are not there, perhaps.
why it is not there? These are all these documents.
These are all his documents.
Then
They, that bid document he did not sign. The bid document is not there, perhaps.
Bid document is not there.
No.
Why you are saying
Secondly,
1/7/2021
secondly,
document is
he,
there?
matter he didn't sign also. Well, let's sign it.
Huh?
See if
It is
they
signed out
signed.
there on
Yes,
top
yes,
and
sign
bottom
as well.
everywhere.
I think what my learned friend is trying to say is there is no
Yes.
digital signature in
It
that
is
one.
clearly
No,
there.
no, no. Digital ko sign in. I will get.
Sign as well.
He did. He didn't see a
I'll
picture.
have to
comment?
have it. These are seal covers, man. So
That's the bid document at page 118.
Yes.
The document which I have taken it out.
না ক্লজ মতে অকল বিড লেটাৰখন চেঞ্জ কৰিব লাগে ইন্ডিভিজুৱেল পেজ 118 ৰ ক্লজটো এই সহিটো আছে
That document I have shown it to you. Isn't that not the document at page 118?
যিটো কোটে দেখাইছে এখন এই সহিটো
well, bid letter in my humble submission, my lord, this is not this single document. The whole tender document has to be signed, my lord. That is the bid document. This is only the
All
forward-
documents are signed. Which document is not signed?
No, my lord. The bid document in my humble submission, my lord, this entire bid, my lord. This entire
Entire
bid
bid
which
is
starts,
there.
my lord, from my lord,
79 to page 108.
32
it
Huh?
starts
It is
from
all
my
there.
lord.
It is not there.
It's my lord, it's a bidding document. It starts from 47.
What?
In
How
the
can that
petition, in the
47
petition, my
be?
lord.
This is not the this is the NIT.
This is the bidding document, my lord. So
This
the
is an
clause
NIT.
says, my lord, the clause says,
Mr. Counsel, this is an NIT. This is the bidding document is the NIT. Are you saying that this is the document which is signed? This is a long e-auction notice?
47, my lord, it's a bid document. It's a bidding document.
Which one?
47 Annex 2, my lord, it's a bidding document. So the clause says,
Clause says what? What is required to be signed?
original bid.
68 of for page 68 of for last line. The bid letter must be signed by
Duly executed original physical copy of the technical bid.
The bid
Maybe.
letter must be signed by so and so. Bid letter must be printed in here. Where does it say
No,
that
Lord,
you have
will
to
come to
submit,
55
you have to sign this
Not
document?
55.
Huh?
55 for a moment.
Yes, where?
55. First round of e-auction.
Yes, then.
Roman 2. The initial after there's a website address, the duly executed original physical copy of a technical bid may be demanded by the authorities at the address specified so and so during the bidding process. In case of difference between the document submitted electronically and original document submitted physically, the original document submitted physically shall be read.
Yeah.
But he didn't. Perhaps he has to sign the entire document, my lord.
That
When he,
document is very much there and these documents are very much there.
only the heading letter is there, my lord.
What heading letter is there?
Only the letter, he submits a bid letter, he signs this only, my lord. Where is the letter, accompanying letter, my lord?
What accompanying letter?
My lord, this entire thing has to be there. Because, my lord, we'll see if there's a checklist. If somebody annexes a checklist, my lord, the accompanying documents, where are they, my lord?
All our these are accompanying our
No,
documents.
my lord, this is not there, my lord.
Which is
Technical
not
bid my lord.
Show me which page is not there.
Take it. Well, this whole document has to be there. From
Which document?
page 47.
Where is it mentioned that from page 47 it is required? Show me in the tender document.
Close.
Where is the file?
But
No, show me the record.
these are
No, the entire Let us see others have
This is
done
the
it.
entire record. This is Ajit Borua. This is Langkung Ragia.
No, everybody.
Yes, madam. 3%. And this is Soikya. This 3%. And as regards my Ragia, madam, I have black mark. This the one certificate is missing.
I'm not concerned with Ragi yet. One with beat.
Schedule to the base कितना?
Just that
Schedule to
51 level. 51.
Yes.
What is bidding document? So what is the update?
Beating the
What is bidding document?
Eight.
51.
What is the serial number?
51 after state government.
There's no serial number. madam. Some bold letters are there.
Bidding document.
No, serial number.
It's not serial number, my lord. Just above 3 before introduction.
Means the bidding document together with the and the document referred herein, including the information memorandum, any agenda to this meeting.
Yes, that's what.
So you mean to say, therefore, that this document is not there?
These documents, the entire bid document, madam. Because madam, there is a dispute regarding not soft copy and hard copy. So
Schedule to
as a common sense, madam, the bidder has understood all the terms and conditions, my lord. That is the requirement that he has to
Now, this document
provide.
it may be required to be signed because these are the terms. Otherwise, how can you make him agree?
My lord, exactly.
Mr. Chaudhary, you
My lord will
efficiently did not
kindly come to page 68, my lord. What technical bid contains? General technical bid comprises of the following documents. Bid letter in format. In case the bidder being a company, a power of attorney, we are not concerned. In case bidder being individual, power of attorney would not be required, but so and so. Affidavit in format so and so. In case bidder being company, duly certified copy of the resolution. All aforementioned documents are required to be uploaded on electronic e-auction platform. Specific instructions for submission of each of the appropriate documents are provided below in each part. So technical bid should comprise of only these.
To achieve moment.
It took long to that point. I found that this clause is to look for the check. Terms and conditions, I agree with.
Technical of language.
Technical bid take बोला कोई भी है, select बोलेगा ना यार. It is where I have agreed to the terms. Affidavit for
What 13.12 with this.
My lord, may also have a look at page 62, my lord. Submission of technical.
Sir, what that's up page 50.
50. Yeah. Yes. Kindly see, this bidding document is neither an agreement nor an offer by the state government to the prospective bidder. Purpose of this bidding document is to provide interest with information that may be useful them in making the bids pursuant to this bidding document. Idea is to, my lord, there is no question of signing in those pages. This is not required. Why is it? Information.
Where is it submitted? Mention that the bidding document has to be signed.
It's fine. It
No,
has to be.
No, that is required because the bidding document mentions many things. Where is it mentioned that the bidding document has to be signed? Because what happens when you see, you see the format of the bid, page 69.
69.
We hereby number 2, down below. Number 2.
We have reviewed.
We have reviewed the terms of the bidding document and hereby unconditionally and irrevocably accept the terms thereof.
Yeah.
So he duly agrees to those terms.
Well,
Now the question is, where is it mentioned that you have to enclose, sign in the bidding document?
Well,
If it is not there, how can you do it?
that part also, my lord.
And the second, as regards the foot fee, there is no problem with that because here he had given for number 4, he has given for another 5. There are 2 things. Mayor mentioning, have you received the 100 rupees or that is the question.
Yes.
Because this, you see, the kindly see page 69. 4 fee stamp of 100 posted cancelled site to the format available at the website. This is the format in which they have given. So that is immaterial. So
Wrong
we are not
mentioning
concerned.
of the number.
Yes. We are only concerned that it is required. We'll take it up tomorrow. 3:30. The matter tomorrow. You take these bidding documents, come back tomorrow with me.
My lords.
My lord, in item number 29, 20, my lord, I'm assisted by Mr. Srivastava, my lord. He comes from outside item 20. Would your lordships give a date, my lord?
20.
Item 21.
You want it? Next step. तारीख कितना होगा?
Yeah, why the matter of 2022 listed for top?
I think his lordship's Manish Chaudhary is not.
Oh,
taking
he's
up.
not.
That's-
Yes, what is the matter?
We are praying. This is my lord, we have filed the writ petition assailing, my lord, an order issued by the state government.
I have filed it.
Sorry, they have filed, sorry.
Who has passed the order?
state level caste scrutiny committee. It's about a caste tribal certificate, my lord.
When do you want?
Next to next Thursday, my lord, on 22nd.
Right.
22nd, I have it. Okay. Then 23rd. 22nd, 23rd. Anytime. Anytime.
25th, 25th?
Yes.
I'm not there anyway. It's the matter on 25th of January 2000. No, 22nd. na.
Tuesday or
On 22nd,
Tuesday. 22nd, I have it.
She has
Okay.
difficulty.
22nd,
then 27th.
20. Oh, no, that will require substantial hearing. That's why.
I'm not there. No. Leave the matter on 27th as this
Oh,
for,
right.
yeah, for hearing. As per the, at the joint chair of the both. After that, it goes to the gate on 27th.
Deep level.
কাম হয়ে গেল, function হয়ে গেল।